God. I almost missed this program. I almost missed it. Hey, Chineke, Chineke. I almost missed it. Chineke, Chineke of obodo Igbo. Chineke. Oh, 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 oh. I almost missed this program. Hey, hey, I almost missed it. They say the judges they enter. They enter court. The judges say they just dey enter court. Who go cry? Who go cry today? Who go cry today? Abeg, abeg, abeg. Na wetin dey me important be that. Who go cry today? Is it Obi or Atiku or all of them? Obi Kerereke. We go watch am live and direct today. You understand me? We go watch am live and direct. I was thinking that I came late, but no, I am on point. You know, I won't make mistake now. They are just entering the courtroom. All the lawyers, they are just arranging themselves, this and that. Oh boy, today now the day, the day where they talk say all eyes on the judiciary. Is it judiciary or judiciary? Hey, our brothers and sisters, how far, how far, who go win, who go? I mean, they don't tell them the answer now. They don't give them everything. They say the court say it's not today. It's not the end of the matter. They say if the court give their verdict today, it's not the end of it. You can still go to Supreme Court. You can still go anywhere. This brother say, YB Chiroma say you will cry if your hope is on any of them. My brother, my brother, my brother. Who, in fact, everybody already know how far now. Who don't know how far? Everybody already know how far. Now, person wey wan deceive himself. You understand me? So they are just arriving the court. They haven't started anything yet. I'm happy that they say they want to stream this thing live now. So let everybody see. Who will cry? That is my own. My own is who will cry. That's my message. You know, my message is always straight. I never waste time. Who will cry? Who will cry? Abdullahi say good morning, Sima. Don't worry, the victory is ours. You see, if you check very well, I say who will cry? Is it Obi or Atiku? Finish. I'm not even talking about President Tinubu because that one is already sealed and signed long time ago. Are you getting me now? Our presidency is sealed and signed long time. That is not what we are saying. Osai Shiriki say na supreme. Then they shout now. Oh, they won't go Supreme Court. Insima, we the city boy supporters will laugh. Have no fear. Coco Saveno say big mouth. Now mouth wey sabi eat food now. Wait. Let me see if I can bring some of their this thing. I've not seen them in the courtroom yet. They are still. I mean, well, they are still in the courtroom talking. You see, my brother Obi Kererenke or Atiku, who will cry? Because at the end of the day, all this their wahala will stop. I salute you, Olomo Karim. I see you. Ayeni Said. Good morning. Victoria Asata. Badmos. I see you. Obidiot will cry. Edixon Edwin say goat. My brother, it's not easy to be a goat. David Amba say you are a big fool. It's not easy to be a fool too. Because if it is easy to be a fool, Obi will not be a fool at 60. You understand? Or 60 something. Abdul Latif Shola say they have been crying they will. Just continue to cry. God bless Jakaban. Nigeria will be great again. Garrison Harry say Nsima, please play all Jakaban song, please. Martin Oladele say tell us all eyes on the tribunal. We shall see how third class candidate will become president. Adeluwa say, I salute you, my brother. You are doing great job. God bless you, brother. Man, I can't miss this program now. Amusa Emmanuel Enita say, seriously, the presidential election has been sealed up already. no dispute. Thank you very much. That is from LinkedIn. I see you. At least I see you from LinkedIn. Thank you very much. Jude Chidi said Nigeria is acting film and you are watching. Yeah, one of the Badamasi Usman said just like you. Please continue. Olurotimi Joseph say if Isima is a fool, the obedient are empty. They always call somebody fool. They always call somebody all kinds of names. No wahala now. No wahala. They always say all kinds of things about me, but at the end of the day, we become victorious. Eze Chinyere John say Jagaban will still carry the day. Thank you very much, Eze Chinyere. I salute you. Yesterday we saw them enjoying the blue light. Is it the blue light rail? Yesterday we saw them enjoying the blue light rail. Let me give you what is going on right now in on the ground. Of course, some people are there's nothing really happening there. Oh, I can see Hope Uzodinma. Wait. Let me put it on the screen. Hold on, guys. Let me just put some stuff on the screen. What is going on there? City boy, city boy, city. Yesterday, all of them, they are enjoying the Lagos train. Oh. We saw all of them. We saw the obedient. In fact, the obedient people, they are the first to rush to go to that place. They are the first to. They are the first to rush there. Look at, there's nothing really happening in the court. People are just smiling, laughing, all of that. That's the only thing that is going on right now in the courtroom. Okay, we can see different people there. I saw Obus Odinma there. The smile was powerful. I mean, everything is coming to an end today, guys. Every day. Edwin say, I know they are paying you for all this stupid talk of yours. Just patient and see, okay? You see, every small thing now they say they pay me. They pay me. Who pay you? Now pay now they worry you, Abi. Samson Peter say, who born this bastard? Now your father. Okay, well I say now your mother. Ajibola say Obi goat are waiting for judiciary miracle. Why my uncommon president are enjoying life in India? You know, that is one remarkable thing about this thing. The president himself is busy doing what he needs to do at the right chambers, while others are making noise. People like Atiku don't have work. People like Obi don't have work, because if they have work, they could have continued their work that they try election that they did not win. If you try election and did not win, what are you supposed to do? You are supposed to go and continue your normal business. But because they don't have business, they are using election politics and all of that to manipulate people and all of that. You see, because if you have lost election, you are supposed to go back and continue your business, continue adding value and wait for the right time. But they don't have. But so they are going to be here. Abi, is Obi coming here? Is Obi coming here? Oh God. Is Obi coming here? Obi Kererenke. So look at what is going. The courtroom is just empty. They are just talking and arranging themselves, maybe waiting for the right time. Jude Chidi say, if Obi did not win, this country will be divided. Trust me, we know the truth. Oh, okay. So if Obi did not win, the country will be divided. If they hear them, they say if Obi did not win in the court today, say the country will divide. Say, yeah, no wahala, my brother. Don't worry yourself. Abdullahi say Obi, Atiku, and all their supporters will cry. The City Boy movement will laugh. Emmanuel Sunday say we are winning. Up Jagaban. Jagaban. Jagaban Ishigaba. Oh boy. I just they see all the obedient. They abuse where they are. All of them just they fire me. My brother, no be me make you to lose. Oh, I say join the winning team. You know, follow who no road. When I know one here. Every day when I go they cry, So if Obi no win, they go divide the country, abi. Every time na rubbish talk, na stupidity, na they always dey come out for una mouth. Oh boy, Nigeria is not going anywhere. We are here. We are here with you. Rather, now we go punish criminals. I'm telling you people, think that we are doing. When we take charge of our country, the city boy said Nigeria is back. We take charge of the country, all criminals will be punished. You don't understand. Wait, just wait. See what is going to happen. You think we have a record of all of you causing problems and everything? Oh boy, see the courtroom. People just came inside just to be taking pictures and snapping and be laughing and be smiling. My brother, to be part of the winning team, it is sweet. To lose, you know, the easy. You know, you cannot forget it. Look at these obedient. They have not been able to in fact to get off or they have not relieved themselves of the shock. They are still crying. They have not been able to get over it. I don't think they will ever get over it because it's obvious. They will not be able to get over it, guys. They will never be able to get over that the city boy defeated all of them. The city boy defeated all defeatables. Yes, me, I supported President Tinubu, so that is why I'm here. If you support Obi, you'll be talking about Obi. If you support So Adolphus, as they say, Mr. Man, you are a criminal, drug baron criminal. Come back to Nigeria. Take it easy, brother. Take it easy. Take it easy, brother. Don't allow anybody to do you maka. So who is going to cry? Who's crying today? Because definitely some people must cry. It's not everybody that is going to smile. I'm sure Atiku will not cry. Do you know why Atiku will not cry? Because Atiku know this game long time. Atiku know this game long time ago. So it's Obidio that will cry. Favor, Media say, nah, make war no deal. Boys, no they smile. This is from LinkedIn. My brother, Favor. Why they always they talk things they don't make sense? Who won't fight? Which every time when they talk things they don't make sense. Talk things that is positive. Talk things that makes it. Talk things that is innovative, technological, skillful. Be saying things like that. Don't be talking every time you be talking about destruction. Are you people only the sons of destruction? Or children of hatred and anger? Every time. Even Mary Odili said it right. I wasn't the only one that said it. Every time you don't talk things that make sense, you say every time you now so when I talk say Niger or Niger Republic, say this go happen. How far? What happen? Amope say the Obi ghosts, the Obi dogs can't read between the lines. They can't see now. Paul Ike say good morning, happy sir. Thank you very much. Badamasi Usman. He say Jakaban all the way, God willing. He's finished. Abdurrahman say in Sima Media we are winning. Olalega say carry your 5 plot of land go. God win. Osaremen say who is this slave? Nsima is a slave. Don't worry. This slave now makes sense. Pass your own. Wasiu Olomo say follow who no road. That is it. That is the summary. Aji Shaba say God bless Nigeria. Thank you very much. Chinebo Ndubisi say hope your family is Nigeria. I pity for them because you don't know what is coming. Let the thing that is coming come. It never come long time. Now it won't. Let it come. Let the thing we won't come in come. Christiana Olaranti Adedidi say it is obvious that obedient have no space in our country. They are so aggressive that they will cry to death today. Omoibo have no space in Nigeria presidency. And they will never learn. Non-entity says of ingrate wanderers. They will never learn. Okay, these are people from the studio talking and all of that. We haven't seen the case. Have not started yet. Of course, it's not yet. It's not yet. Let me see another channel. I'm looking at the channel that are there live and direct, so to see if there's anything they have. Everybody just giving their own analysis. of what they feel and what they think is going to happen. And that is why we are here, guys. We are going to defeat all defeatables. There is nothing that is going to there is nothing that is going to stop us, guys. We will defeat all defeatables. We have always been defeating them. This is not the first time. We have always been defeating them. And I like what Femi Falana San said to them that if you know the court judgment today is not going to be the final, and that you can go to the Supreme Court, and then he also makes mention something that is very important, that no intimidation of the judges or whatever that is going to stop what the rule of law or what they're supposed to do. Because there have been, when Femi Falana was talking about intimidation, he was talking about the obedient people now. They are the one intimidating everybody, saying all kinds of things. As you can see now, in my they are trying to threaten me. Not with me causing a problem. Oh. I'm only trying to help you people, but you are not seeing it. No wahala. Martin Oladele Talo said, today is the day. All eyes on the tribunal. We shall see. Samson Peter said, Omo, I pity your generation. Ah, my brother, you pity my own generation while your own generation is gone. Masiu Adeshina say President Bola Ahmed Tinubu for victory, inshallah. My brother, our president is enjoying and doing what is necessary over there. I think our president is still in India, the meeting in India, the G20 summit, arranging things and making things to work. Are you getting me now? Leave all these people. We know we have defeated them, man. We are just, we just want to seal off everything. Are you getting me now? I've got lots of messages, guys. I'm sorry. I thought I should drop this for you if you're interested. Another shocking revelations. Hey, it's coming, no, it's coming. It's coming. It's coming. We have lots of things that we are going to fire down later, but not now. You see, we want to take back our country. The city boy say Nigeria is back. Somebody say, bros, you don't say to what happened here? You see, you don't say to wait. Now look at them in the courtroom. Who is coming in? Oh boy, na prayer be that. Okoko bioko. What is it? I don't go kill me. Thomas Sankara say most of the obedience they be struck with they are going to be struck with hypertension today. Yes, yesterday they've scattered some of the NLC people. You know all these NLC. I told you people, yeah, these people don't want peace. They are not working for the country. Today now you saw they say NLC they put national strike or whatever. In Ogun State and other places, they drive them away. They say, get out of here. People are not working for the people. Is it in Ondo? They're driving all of them away. So get out of here. These people, we are going to take back our country. That is what the president said. This time around, the patriotic Nigerians will rise up to stop all this criminality. All these people shouting up. You will see now. It's coming. The time is here. We are just waiting for the court and everything to be done. Of course, today is going to mark the beginning of taking over by the patriotic Nigerians. You will see now. Anytime I say something, just know. Enough is enough. We have been giving all these obedient to all these people, IPON, Biafra, criminals from the southeast. We have been given an opportunity to be making noise or for repentance. They have been talking rubbish, doing all kinds of nonsense. The patriotic Nigerian, when we rise up, they are the one that is going to run. They will run. They will run and leave our country for us. What did I say? I said they will run and leave our country for us. Very, very soon. They will run and leave our country for us. Because all of them, they were enjoying the rail line yesterday. See IPOB, see IPOB, what they call it, lawyer. I see him there. What's his name again? See them, see them. IPOP lawyers. They know what is happening. They know the real deal. Uh, Martins replying to something say, and you are in Omope. Shame upon you. Martin, no worry. These people, I know them. Afisi Ibrahim say, yes, daddy, today you must go back home. Obi and Atiku, stop crying. Thomas Sankara say, most of the obedience will be struck. Okay, I've read that before. We are the winner forever. No one can be like Jakaban. That is from Khalifa Adam Abdullahi Orowi. Thank you very much. Adolphus Eze say, you are one of the criminals. Yes, so and we are one of the criminals that have defeated Obi. Jude Chidi say, Nigeria must be divided if Obi didn't win. I have told you, you cannot do anything about it. You are just running your mouth. Jude Chidi. Okay. Now so now they talk. Criminals. You say you want to divide Nigeria. Who will divide Nigeria? Now you. Only one fraction from the southeast. Only one fraction from the southeast want to divide Nigeria. Ugoma Nwachi say, Isima, my man. Adekunle Omoshebi say, good morning, Isima. I see you. Thank you very much. OA Amokbe say, it is finished. We've already told them long time ago. It's finished. Martin said they are full of bitterness and anger and frustration. Child, this tribe, well, is some few criminals. That's all I can say. Khalifa say, more blessings to you, my brother. We are on top. Always, always. Harrison, Garrison, Harris say, just look at the countries that had coups today. What are they achieving on daily basis today? Exactly. We told them. We told them, don't worry, they want to cause problem in the country. We refuse. We refuse that rubbish to happen in that country. The countries that had coups, have they been enjoying? No. They are not enjoying them. Nothing is good about it. Though. Nothing. They are not enjoying it. Nothing is good about it. They are talking rubbish. We have told them that military coup is not the revolution of the people. Revolution of the people is when you stand up and hold your governors accountable, leaders accountable, responsible. That is how it's supposed to be. But since they don't want to hear, why would they? Understand me? Yeah. So just look at the countries that had coups today. What are they achieving on daily basis? Today, our guns keep on buying guns, tanks, no companies, no good infrastructure, no good health sectors, everything so useless. Then Obingos are also paying that they want to fight. Fine, may God deliver them. They already been delivered. So, guys, I'm not seeing anything yet from the court yet. They are just there's nothing that I've started. Nothing I've started yet from the court. So, and we are just here in live to give every update that is required. Are you getting me? So we are going to make sure we see what is going on. Are you getting me, guys? What is wrong with this thing? So that is why we are here. They will not succeed, man. They will not succeed. If there is any good example of anywhere they say the coup take over and things are better, then we would have been talking about it. We could have said, okay, maybe things are going to be better if military coup took over Nigeria. But there's nothing. Let us listen to what this brother is saying.
It's a class of lawyers just waiting. Just waiting in the classroom right now and with the lecturer just to take notes and look at all of the angles to this thing. So how significant do you see this? One of the things that you said earlier about this particular case is that this is the first time we have 3 leading candidates who have taken their cases to the court. First time ever in this country, we've had a situation where there is one winner and a second, person who is taking on. But this is the first time we're having 3 leading candidates who are claiming their rights to the throne. How significant do you see this in legal education and an education of the populace about legal matters?
Well, incidentally, in terms of enlightenment of the public, I have my doubts. We do not have a reading public. We don't have a very enlightened public. This will only circulate amongst the elites, those who take pleasure in knowing what is happening, those who take pleasure in current affairs. Earlier, I did say something about the digital generation. So this, to a large extent, will further enlighten the digital generation, the Nigerian populace as a whole. I don't think they could care less.
So you see it playing a role in educating the digital population?
I believe that so strongly because, I mean, we're talking about the law, all right? Now, anyone who is discerning will say this, that this particular decision will shed more light in relation to these constitutional and statutory provisions. Earlier, I remember it was also saying something about non-compliance with the Electoral Act and the burden that is placed on you to charge. We've had cases where the Tribunal placed a burden on petitioners that the petitioners were unable to discharge. Recall that our system is heavily based on determining cases based on preponderance of evidence, as opposed to a criminal case where you're meant to determine your case based on proof beyond reasonable doubt. Now, able to come up with evidence. Now, what is the evidence that PDP and Labour as political parties have placed before the court in relation to the ground of their petition?
So, guys, everybody is just talking their own, and we are here talking our own too. The bottom line is cry today because somebody must cry. That's it. Somebody must cry, you. Somebody must cry today. Are you getting me now? I'm going to try to show another angle of what is going on inside the court. Are you getting me? If you are watching me today, our own is different because it's a town hall, blah blah. A town hall, different from balabulu, bulubla, bolo bolo. It is here. Ajibola said the crying is not new to Atiku. This is from Ajibola at the best. He said the crying is not new to Atiku. More than a decade he's been crying. Obi Goat, crying is the headline of the week. Up Jakaban, the uncommon president in the history of the world. That one sweet me pass. Now that one sweet me pass, guys. It is here. Then they give you the way it is. You understand me? Because different people, they understand differently. Some people where they don't deceive say, say if this don't happen, say they go divide the country. Earlier on today, we saw the vice president, the uncommon vice president was in the courtroom today. We saw the uncommon vice president today in the courtroom, just to let you know that our people are also, you know, look at the view of the other side of the court. We saw the vice president earlier. We saw some other people. All of them are here because today is the D-Day. Today is the day Obi is going to cry loud. We already know what we can do now. They say they want to cause problem. They want to fight. And I tell them, say, no be who fight, now him go win. No. No be who start fight, now him go win. Told them many times. If you start fight, no means say you will win. Okay. Amope say they can go to Supreme Court to waste more money. Williams and if you say you don't know how to talk to you, you are a foolish man. You don't know how to talk. You are a foolish man. Exactly. Williams and if you, I don't know how to talk. It's true. Don't know how to talk. And I see how you people know how to talk. And you have become a failure. You failed in everything. You failed in Biafra. You failed in Obi. You failed in IPONG. You failed now in presidential. You failed in developing your region. You failed in everything that concerns you people. Everything failures. You that know how to talk. Bunch of criminals. You want to come and lecture us how to talk. Idiot. Watch out. At the end of the day, we'll find out who know how to talk. Daniel said tribunal judgment will favor Jagaban. All the obedient and articulated must weep well and snatch their teeth today, because they have no evidence that they won majority vote in the election. Thank you very much for that comment. Khalifa say, my brother, continue your work. Let them say. My brother, continue your job. Let them say. Jude say, you are just making noise. Now so they make noise now. We win all of you. Not so we make noise. We win all of you. Awala Emmanuel say, victory is sure for Tinubu. Williams and if you say, you talk in favor of yourself, you forget that you are a young guy. Look at this bunch of criminals. You want to come and teach me how to talk? If I'm a young guy and say, what happened? So I should be acting like stupid people like you, eh? I'm a young guy now. That is why I'm doing what I'm doing. I'm a young guy. Prince Babafumi say, President Bola Tinubu will win and win again. The Obingos are just wasting their time and all of that. You can see now. Look at all of them. They are still sitting down. The court proceedings have not started. All of them are just seated. All the lawyers, almost all the lawyers today, they want to learn. There's a lot of things that all of them will learn. I get me. So it's okay. It's a welcome development. Khalifa Adam Abdullahi say, Mashallah, Tinubu is our president. Our Apostle Wisdom Onebu say, this senseless young man better seek wisdom before coming publicly to say nonsense. My brother, show all of you they watch me. Keep watching and monitoring me and see how far. We are here. Ajibola Okunji Ajibe say, not obedient. Instead, obe less. Martin, don't worry yourself. Leave these people. Saliu Jimo say, Obi and Atiku will cry today in Jesus' name. Amen. I can't any other thing happening. I'm beginning to prophecy. Come. The only thing I can see is that Obi goes and Bingos, they're going to be crying. They will cry more. And this time around is a public disgrace. Remember how we defeated them before during the election? This one is another confirmation that we are going to defeat them again. This is a public disgrace that is going to happen again. Are you getting me? So of course, it's not about. Remember what they said. They said they want to nullify our president. They want to that President Tinubu is not qualified to be a candidate to be the president because of this, and that. Those are the things that they brought on board. So today we want to hear what the court is going to say after much findings and investigation. I believe that they have something to say today, guys. You understand me? They know what to say. They have the right answers, and they still have opportunity to go to Supreme. You know, if they call it, the way they will pronounce their own Supreme Court, they have opportunity to go to Supreme Court to maybe for if they don't agree with the judgment today, they can go to Supreme Court. That one will be another one. I get it. That one will be, will I say, another confirmation that we are always victorious. I get it now. So we'll continue to win. The City Boy has been winning now. Can't you see what happened in Lagos? Yes. Abuse the governor. Oh, they say governor did not like us. NSAS. All of them, they were enjoying. All of them they were enjoying. These are lessons. These are the things that the governor should learn. Lagos has set a standard. There is no country that is better than Lagos. I say, I want to repeat it. There is no country in Africa that is better than Lagos right now. There is no country. I'm not just talking about the rail line or whatever. In terms of GDP, in terms of economy, in terms of everything, there's no country yet that we are seeing is better than. Is it South Africa? Is South Africa better than Lagos? No, it is not. Yeah, it is not. So this is what we are talking about. So the governor should learn from all this. And I've not seen them. I've not seen the people shouting Ipong, Biafra, Biafra, or Obi. I've not seen them started asking questions. What is our own governor doing? You know, they were saying that Ojukwu is their hero. They asked, what is one thing that Ojukwu did that you can use to remember Ojukwu as hero in your land? There is nothing. You see, that is why we cannot say somebody is an hero when he did not achieve anything, when he caused problems, caused fight, caused issues, generation to be crying up to today. Show us one thing that you used to say Ojukwu was an hero. Show us one thing that he did. Show us maybe a building that he built. Show us maybe a school that he did. Show us the road that he constructed. Show us any project that was done by Ojukwu that today has add value to you people that you say is an hero or whatever. There's nothing. I told you they always celebrate criminality. Simple. There is nothing. I asked them, what make you to be calling Ojukwu a hero? He's a criminal. He was a criminal. But they are praising him today. That's why all of them are saying Biafra, 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 Biafra. Chukwu Creed say, what if Obi win at the end? What will Obi will win what? This is one of the comments. He said, Chukwu Creed say, what if Obi win at the end? What will Obi win? What is he going to win? What is he winning? Is it to be the president? From third position, he will be president. How? Man, some people just live in. I believe today all those your deceit will be cleared because all of you have been deceived for a very long time. Abbas Ola your day said now obedience will start crying in future when Chicago University start rejecting anyone from Southeast for insulting the vice chancellor of the school and the governor of the state. Egbo people. Is that what I don't even understand what? Yesterday they were firing Femi Falana because Femi Falana said something that there is no intimidation of the judges that is going to affect the outcome of the tribunal or whatever. They were abusing him. The other time they were praising him. Yesterday, during that interview on channel, they were abusing him. Was it yesterday or which day? They were abusing him. They abuse anybody that did not favor them. If you say something that do not favor them, if you say they will abuse you, he said, now that is what they are doing. So we are not. It's not new thing to us that they are abusing maybe Chicago University or anybody. It's not because they believe the lies. I told you that thing that Obi said in court was the thing that IPOP have been preaching for 10 years. I did tell you this thing before. I played it now. The video is there, just that it's not very, very clear. I said everything that Obi listed in the courtroom was what IPOP was shouting for 10 years. That was the propaganda now. I told you. That's why we know that Obi is IPOP. Everything. Oh, the main man just entered. The judge just entered now. Guys, we are just watching. The judge just entered. So Chukwu, tell us what Obi is going to win. If you say Obi will win the end at the end, what will make him? What is he winning? So we can see that the judge have just come in now, right now, and maybe the proceedings will start as soon as possible. Olurotimi Joseph say obedient and the articulated will forever know the price of victory, but never will they know the value of it. Price and value of victory is absolute right of the ratified. TJ Amasa, thank you very much. I know you guys are replying these people. Just leave them. Ajibola said they want to divide and they are still the first person to jump into the uncommon blue rail in Lagos. Senseless people. Yes, we saw some of them yesterday now. Some of them were saying, oh, I don't believe that this is Nigeria. Jude Chidi said you will cry with them. No, I can never be part of the losing team. I will never. I will always, I know where to enter. I will always be part of the winning team. Check out now. I will always be part of the winning team, guys. I will never be a failure. OA Amogbe say breakfast will surely be served today. Easy facility, yes. Say all their pastors now doing video both days and nights. Oh, they are doing video. Those ones are deceiving them, and they have always been deceiving them. Obingos must chop breakfast today. Obingos must cry today. Cheya, una dey finish these people today. Oh. Martin said they are still in their bushes. The unknown gunmen fighting for their Biafra. Why they are still in the court fighting for their throne away stolen mandate. Chai. Oh, but we can't wait for this thing to be over now. Mm-hmm. I can just imagine what the president is doing now. The president is serious, in his meeting, G20 meeting, in India. Why the disobedient? Oh, look at the IPOP, the Biafra lawyers. Look at them there. You can see all of their faces. It's familiar faces. They are the same people that is representing IPONC. They are the same people representing Obi again. Oh boy, see all the lawyers, all of them are just sitting down to learn. You see, this city boy government has brought a lot of things, different things. It's going to enlighten the public. It's going to educate people that don't know. In fact, it's a very good opportunity for many people to learn. Are you getting me? You okay? You okay? Very good opportunity for many people to learn. I'm telling you guys. So it's not a bad thing that this is happening. We love it. We love it. We love what is actually going to happen today. Are you getting me? K say, how can third in position claim victory? I don't understand. I don't understand this. People try to use rubbish social media blockers to threaten the judiciary. It's obvious now. It's obvious. We are happy that everything happened. See, we have a record of it. All the activities of IPOP Biafra obedient are criminal activities. They are criminal activities. Simple. Jimo Adeniyi Olalekan Friday say, hello, daddy, and his followers will cry like baby. You mean the yes, daddy people? Cheya. Abdullahi say, Obi still waiting for pastor's miracle, whereby his red card for him. Obi has already given up now. He knows. He has already given up. K say, can these Obingos do this rubbish during Obasanjo regime? Martin say, yes, daddy, is a religious war. What a shameful thinking. Ajibe say, they can even fail in social media. Garrison say, DSS will pick so many people today. Ajibola say, we make noise to silence IPOP and Obigoat. We did it now. They say Nsima is making noise. Now wow. My job is to make noise. Anything that did you hear what the Gabon president said the other day? Make noise, make noise. They have captured me, make noise. We have been making noise. So we make noise to let the whole world know that the IPONC criminals, what they have been planning. First of all, they say they want to take over Lagos. We made noise. And today they are nowhere to be found. And somebody is talking rubbish. We made noise. Forget it though. Our job is to make noise. Because we are patriotic Nigerians and we don't want any. Oh, president speaking. It's like the vice president wants to speak. Hopefully, if he's talking, I'm going to put on the mic so that we can hear from our own vice president, guys. Oh, they are introducing the representative. Okay, the people that are representing the various parties. The vice president was there, and we saw Abure. Okay, They are introducing themselves, the people representing different parties, right? That is what they are doing right now. Okay.
Person was in court.
Absolutely. So it forms part of the record of proceedings for that day.
Is a party.
Absolutely, absolutely. Absolutely. And it's a fine moment for lawyers to, in fact, at a point there was something trending.
Okay, I think they are just showing up themselves.
Okay, all right. There was, a trend at the start of
they are just showing
the
who
election
is
petition saying
today, right? That is what is going on, guys. So we are live and we are following up everything. We are here. Everything we are gonna be here to tell you everything. We are live and direct. Our own is different. But don't forget, our own is always different because we understand what is going on more than them. I get me. The Obingos thought Obi is a youth. They know. Look at what happened in Lagos. Can you look at Lagos and Anambra? It's incomparable. Look at the rail line. Look at what did Obi brought to the people in Anambra? Ompa. You know the meaning of Ompa? Beer factory. Hey, our man is there. Our main man is represented. That's the chairman of the party, APC. Everybody is well represented, guys. Everybody is well represented. Everybody is well represented in this today. Everybody. Somebody say, Olawa Femi say, is Kenneth Okonkwo in the court? Oh! That is a very good question. I don't even know where Kenneth Okonkwo is, guys. I don't know. I've not seen that man for a very long time. Kenneth Okonkwo, where is the brother now? What happened to him? I've been on tire or I don't know the truth now. I've not seen him. I don't know where he is. I hope he is safe. Because we want everybody, all the naysayers to be alive. We want all the naysayers to be alive to see our president succeed. That is our own. No? You understand me? We want all of them to be alive to see our president succeed. All the people talking rubbish, say all kinds of things. We want all of them to be alive and see the president succeed in everything. You understand me? So I don't know. I don't know where he is. I've not seen him. I've not heard from him for a very long time. You know? So yeah. So I think some of the proceedings they have started. Let's see. They are just going to be talking, and then we'll listen to some of them, guys. Let me try to connect to some of the things that they are saying, guys. It's just introduction of the people. They are just introducing themselves, different people that are being represented. Let me connect to another one that might show properly, because some of them are not showing properly, guys. Let me connect to another one. But what I'm seeing they are doing is they are just introducing themselves and all of that. You see? Basically, that is what is needed. Introduction of different parties, representative, everybody that is going to be representing their own. That is what they are doing right now. Let me put the volume. You want to hear? But basically, that is what is going on. You can see them.
Members of the outer bar.
You see that?
Because 3 of them, starting with number 8.
They are just introducing themselves and they will stand up, they will bow.
Precious Uchendo.
Basically.
And finally, Igwekama Ubiora.
So many people are represented.
Together, we appear for the petitioners, my lords.
At the end of the day, nobody will not know what
the iron is crusher.
He couldn't be accommodated to them.
Yes, first respondent.
If it pleases my lords, I am Sir Stephen Adehi. I appear with my learned friends of the inner bar, T.M. Inua, SAN, Al-Hassan A. Umar, SAN, Suleiman Olawale Ibrahim, SAN, and our friends of the outer bar appearing with us are Nasara H. Auta Esquire, Aminu Sadauki Esquire, N.A. Atta Esquire, Susan A. Imrosi Esquire, Jamiu Aguru Esquire, and Martins F. Ekpa. We all appear for the first respondent. Thank you very much, my lords.
Second and third respondent.
With profound humility to my noble lords, my name is A.A. Malik. My humble appearance is for the second and third respondents. And as my learned brothers of the inner bar, appearing with me are Babatunde Ogala, SAN, Dr. Remy Olatubura,
So guys,
SAN,
let's continue our talk.
and
They are just introducing themselves. When they start doing something tangible, we'll talk about it, but they are just introducing themselves. I'll be taking some of your comments. The question is, who will cry today? Is it Obi or Atiku? And we are of the opinion, based on what has happened in the past, Atiku will not cry because Atiku is used to the something. He has been doing it for a long time. It's not the first time now. Even Femi Falana said, right from the history of Nigeria, there have been petitions, tribunal, after every election. Nobody died. And so why is now obedient or is it a new thing? It's not a new thing. So Patrick and him said their petitions will be dismissed and sent to the incinerator. Wait, what are they saying? Let me see.
Fourth respondent. With me, sirs, Chief Adede Akintola.
So those are the respondents. They are just introducing themselves, guys. So let's just continue. I want to see your comment on these things. Who is going to win between Obi and Atiku? We know who is the winner already, but we are saying who is going to win between Obi and Atiku? You know the level of cry. Who will cry more? That's the question. Who will cry today? Who will cry more? Is it Atiku or Obi? We know that Atiku will not cry much because we already know. Kai, is it K? K say what of their pastor Paul Eneche in Supreme Court now? Oh, we have not seen Kenneth Okonkwo yet. We have not seen Pastor Paul Eneche. We have not seen them yet. Martin say all of a sudden all those idiot prophecy ran away. Please tell us what your God says. So all eyes on the prophet. Adeyinka say Atiku and Obi will cry today, inshallah. Ajibola say Asari Dokubo is enough to silence them. Oluwafemi say Nsima, where is Okonkwo? Everybody is asking about Kenneth Okonkwo. It is gone. Amokbe say Ojukwu failed to impact his people positively. We are telling the realities. Can you imagine now when Babajide, His Excellency, the governor of Lagos State, when he's finished his tenure? Do you think that we'll forget about him? We will not forget him. His name is written on gold. He's part of the people that succeeded to make sure that there's a rail line in Lagos. We know that it started since 2003. The foundation was laid by President Tinubu as at that time, His Excellency, governor, of course, as at that time. But now it's been succeeded because now everything is done, just like what we are expecting to happen in Anambra. Abga have been running Anambra for long. We are expecting Oka to be a success, but it did not work. Hey, our APC chairman, see him. Kanduje. Wait, I wanted to play something. We saw what happened in Lagos. All of them, they were enjoying. They were enjoying the blue. Look at our vice. Hey, uncommon vice president. Let me see if I can capture the blue rail line. I think I have something like that. If the network is allowing me, because I have so many things open at the same time. Let us see this. We saw them yesterday. They were enjoying the blue rail line. Wait, let me see.
Walking. Lagos is walking. Lagos is walking. Lagos is walking. Lagos is walking. The joy As you can see, the joy on the people. People are so happy. Somebody say, oh, God bless you. The governor is working. God bless you. Somebody say, Lagos is working. You see, the people are forgotten about all the bad things. Now everybody happy, smiling because they can see what the governor is doing. The blue line rail in Lagos is working. People are enjoying it right now. You see, people are happy. You see the people, the way they are smiling faces, or the smiling faces. In fact, somebody said that if you are not in Lagos, sorry you. You see, this is what we have been talking about. We want a government leaders that will do something tangible for people to see, that will benefit the public, a greater number of the people, and it's not few people that will benefit from it. You see, this transportation system now, this railway, of course, using the train will solve a lot of problems. The traffic issues, all those kind of things will reduce, and then more is coming. You see, this is what we want. Look at the happiness on their faces. That is the joy. That is what we want to see. We want to see Nigerians happy, enjoy, smiling, because we have everything that we need. In fact, somebody even said that I can't even believe that this is Nigeria. It's because they have not been used to a government that makes things to happen. It's because they have not been used to government. Look, I just want you to listen to their testimony, guys, because I don't need to talk too much. I want you to listen to their testimony to tell you that in this administration, the city boy government is going to do a lot of things. The city boy government is a government of the people, by the people, and for the people. The city boy government is a government of unity and democracy. For me, I'm so much happy because I'm fulfilled. Because I can see that in the next 4 years, there are so many things that will put smile on the faces of Nigerians. All these things, some people are shouting, they will forget about all these things. They will not remember the sacrifice anymore. All they will see is happiness and joy and smiles, because the city boy government is going to do a lot of things. It's going to disappoint anybody that thinks that is going to fail. The city boy government is going to make things to work in this country. Just listen to all of them. Listen to the experience.
The thing is that it's still need to be Nigeria, but we are believed it. Come on, God bless you. We're happy, Lagos State is working. We're happy about that. We're happy.
No more suffering, Nigeria. If you're not in Lagos, you don't sorry.
This is a maiden trip, and it has to go smoothly. I have my card, and I'm hoping that everybody has.
At the breaking of the day, I thank my Maker, say I see today. The clouds.
My experience on the train, this is a welcome development, for Lagos. It was really, it was fast, and then we're able to get to our destination pretty okay. With this new innovation, I believe that traffic management will be way better in Lagos. Overall experience, it's an amazing innovation, and I look forward to more innovations like this in Lagos. Thank you.
From the fury of yesterday to faith.
The experience was very electrifying, very interesting. The students we brought really enjoyed the experience. We are from Lagos State Resident Registration Agency. Our card, like ID card, could also be used to board the train.
My experience was very smooth. The landing was very subtle. I really enjoyed it. And for commuters coming in from 2 to Marina, it's going to be a smooth ride. You have nothing to worry about. I understand that it's a fully energized train. Okay, so the speed and the travel time will be really, really reduced, unlike maybe flying a BRT or a public bus. It's going to be a very subtle experience.
Excited. It was her first trip on the train today, and we came from Igomu to Marina, and it was very smooth.
Was it seamless?
It was seamless.
Did you enjoy the Wi-Fi as well?
Yeah. Oh, there is Wi-Fi.
There's free Wi-Fi. There's free Wi-Fi.
Oh, you see that? That was Lagos. That is Lagos. That is Lagos. That is Lagos. A success, a complete success. So that is how Nigeria is going to be a success. Let us listen to their proceedings, guys, because it's like they have started their whatever. Court proceeding, no be small talk. Then they talk, move the hear.
It's my prayer for him, my Lord. My prayer for you.
Yeah, that's what I
think. Olayewaju Akinshola, Esquire.
They are still bringing their people.
Bolaji
They
on
are still talking about their people. I beg. Let's continue. Let's continue. They are still talking about their introducing whoever that is in the representing the court. Somebody say Ojuku failed to impact his people positively. Some Khalifa say for where Obi go win, I think it's going to be Anambra president. Martin say where are the my God say what a shameful thinking religion bandit. Amope say Obi that came distant third can never win at the tribunal. Ojibola said Osigini who say Obi win, tell him to go and verify from Obi himself. Martin say abusive and insultive is in their DNA. The whole wide world has seen how hypocritical these things are, or how hypothetical these things are. How can you use less than noble name of Ndigo? Chai. Oh, guys, this is advert. Hold on. Let me remove this advert. What's going on there? I don't know that face, so now advert with that. Guys, they are still introducing themselves. They are not doing anything major now. Obi will win. Please, may God help him. It's a good prayer. Everybody must pray prayer. Thank God. May God help Obi today. If not, he will be crying. Prince Adebisi said, no single tribe that can intimidate other tribes in Nigeria. Ndi Igbo should respect Nigerians. K said, this useless Rufai Oseni must cry today because the guy is full of deceit and embarrassment to journalism, profession, and history and youth. Rufai does not represent the youth. He represent his own. Are you getting me now? He said, hey, I'm from Anambra. God will say the final today. The victory is going to be with Tinubu and Shetima, God willing. Martin said they are so negative. They see nothing good. Chai, continue. Where are all the fake Obingo pastors? Thank you, King Insima. Where is Okonkwo, the hungry lawyer? Where are the fake Obingo's pastors? Everybody's asking that because it's going to happen today now. Kenny, baby, Baba Yemi said, good morning, Insima. All these Obingos, people let them start crying from the one of our president. Yes, daddy will be no daddy today. Kenneth Okonkwo has joined the unknown gunmen in the bush. Adeshina Femi said, Insima, they already know what it's going to be. Let them continue crying like a baby. Jakaban. All right, guys. I'm just waiting because I don't know what they are just introducing themselves and it's very, very slow. Oluwaseun say confuse people in the state of dilemma. After the tribunal verdict, they will come up with another zombie movement. Atiku is a mature political mind. Bello, thank you. Akinwumi say, who are noises makers and complainers? They did not even show us what's his name? They did not show us that you. They did not show us Obi. They did not show us Atiku. They are not there today. Chai. They no one carry shame. Chai. Who are noise makers and complainers than them in this country? But they refuse categorically to do the same thing concerning their governors and local authorities in their state, in the southeast, for lack of development and security. You see, Obi knew. Now, it's not there in the court. Now. I can't see Obi. Everybody is introducing themselves. I did not see Obi. All these people introducing themselves, I've not seen Obi now. Are they still waiting? Where are they? I've not seen Obi yet. You can see many people introducing themselves. I've not seen Obi yet. Jimo say Obi knew how to cry on national TV. Remember how Obi cried that somebody did not have money to start a bakery? Hey, Kanduje! Oh, look at Festus Keyamu. Look at Dele. All of them and Vice. All of them are saying, where is Obingo and Bingos? I did not see them. Somebody saying, where is Obi? We have not seen them. Oh. Where is Atiku? We have not seen them. Osai Sheriki say Atiku is a good customer. It's only Obi that will cry, yes, daddy. Atiku is a mature. Obi will cry more like a baby today. He took third position, claiming he won the election. Where is he done? If he doesn't have a mischievous plan to destabilize Nigeria with IPOP members, I've not seen I've not seen them yet. I've not seen Obi. I don't know where he is. Maduka says, shameless man like you, shame will be your portion today. No wahala. Who is supposed to be ashamed? You lost in everything, you're still making noise. Dage Aderemi said, today expect premium tears from obedience in a few hours and maximum propaganda. The judges were bribed. Oh, okay, their propaganda, they are going to say the judges were bribed. If you sell handkerchief and tissue papers, expect to profit from obedience today. Child. Yeah. Odili Stanley Chuk said today is happy and crying Obi, and Obi is crying Jakaban, aka City Boy Man for life. That's Lagos they condemned during election that they went to bribe Badebo will their Badebo Labour Party candidate do that if he won. Where is that guy said? I don't even know where the guy did. Okay, guys, let's listen to their conversation.
I pray for the petitioners, and with me are my learned brothers Silk, namely Eyitayo Jegede SN.
This introduction plenty.
Yes. Professor Mike Ozekome SN.
This introduction is still plenty.
Nela and Ewa Rabana SN.
Have you seen it? They are still introducing themselves, guys. They are still introducing themselves. We have not seen Obi. We are looking for Obi. Alade Lawal say, big bossa to you, only first son of Idu. May Almighty continue to guide and enrich you in wisdom. Amen. Thank you very much. That's the kind of prayers we accept. Ibrahim say hi in Sima. Thank you very much. I see you on YouTube. Thank you. Stanley Obonna said, please leave that one. Maybe God for this one now. Maybe here waiting you they talk. My brother, what are you saying? Stanley Obonna, what happened? Now, every time they say God, God, I mean, God, they only favor you people. Say, now only when I get God, Abi. Other people no need God. You know, they talk these things sometimes. So, Stanley, I didn't understand your conversation. I don't understand your conversation, okay? Today the Obingos go weep. This is from Wilfred. Thank you very much, Wilfred. Stanley say Obi win no matter everything. They are talking. Obi win the election of Nigeria. Exactly. Obi won the election. Very, very good. That is what you believe. Good luck to you. All right. No matter what they talk, Obi win. Okay, yeah. Okay, yeah. That is what you wish. But it's not happening, brother. Aku Wumi says, thanks, Mr. Nsima. You are doing a great job. God bless you. Thank you very much. Innocent Madu Kasi said, you don't have job. Stupid boy. I don't have job. Give me job. I don't have job, but I'm live. And you are talking. It is a person who no get job, he come live. Olubukola David said, Jakaban all the way. Obi has already nailed his political doom for the future. Ajibola said he is in Arise Channel's custody. Obi is with Rafai at Arise Channel custody. Oh, Obi is on Arise now. Is that true? Wait, let me check. What is he doing there? Everybody's supposed to be in court. How can Obi be on Rise? Everybody is streaming the program. Okay, I saw what Rafai said. Rafai said, judiciary, please be just in your ruling. Hey, Is Rufai trying to bribe the judiciary? Listen, no.
You are to be just
Uh-huh.
and be above board like Caesar's wife. And rule in tandem with the rule of law and the laws of the land.
So Rufai wants to tell the lawyers what to do, or the judges what to do. Eh? Rufai said that the judges should be just. What was he talking about? Listen.
At a critical point in our history.
Uh-huh.
At a critical point where decisions that will be made by the judiciary will determine the future and the sustainability of Nigeria.
It's a lie. It's a lie. It's not what the judge is going to say now will determine the future of Nigeria. What are you talking about? Petition has always been there for many years. That is why we say this man on White TV don't know what they are doing. I don't know who is still paying him on White. How can a petition, just a petition, is not a new thing? He's been always there. Every time after election, people always have issues. They take it to the court. Are you getting me now? The court will always do their job. They have always been doing their job even before you started being interested in politics. The court have always been there. They have always been doing their. So that is how to tell you that this on White TV, their job is to try to promote Obi. Simple.
You are to be just
and
be above board like Caesar's wife.
That is what the judges will do.
With the rule of law and the laws of the land. Be dispassionate. Be forthright. And stick to the law.
Okay.
There are no ambiguity.
My brother, the guy they talk rubbish. They waste my time. Okay. He's talking rubbish, wasting my time. He said the judges should be whatever. Is that not their job? So Obi is with Rufai at the Rice Channel custody. Let him come talk now. We are waiting for him. We did not see Obi. Obi is not in the court. Yeah. Nobody have the monopoly of God. God is for all of us. Exactly. I've been telling them now. Every time they mention God as if God knows them. Addition of Remy. Obi cannot show face like Atiku because they have been attending court like morning and night as if they don't come to court one day, they are going to be punished. 99% of attendance, but today, which is the D-Day, they absent, telling you that they are a failure. Exactly. So Obi is not in court today. Atiku, there's nowhere to be found. They have been going to court now. Obon Naya Nwachi said, Nsima, thank you so much for bringing the proceeding to us live. I'm following up with my phone. Martins, thank you very much. So you see, Obi is not in court. I've not seen him. If you have seen Obi, tell me. Are you getting me? If you have seen Obi, tell me. There is nothing going on in court yet.
Deliver the judgment, but you know that we all know the rules concerning.
Wait, let me.
Matter.
Let me try to get another one that is going to be a little bit. I can't hear what they're saying. Their volume is not. They are saying something, but it's not very clear. They are just reading something. Osai say Obi will come late to distract the court. He likes attention. The obedient, they are waiting for him to shout Obi to deceive Obi fools on social media. Oluwafemi said, Rufai working
remember that
for the
during the judiciary session, several motions were.
Obi gave him for his modern burial.
So we shall begin with the consideration of this application before we proceed.
Okay, I think they want to start.
So in this petition, that's petition number 3 and number 4, sorry, the petitioner herein Allied People's Movement participated in the presidential election conducted by the first respondent on the 20th.
Let me bring the other one to see if that one will be clear. Hold on, guys. Oh, even this one is don't even have volume at all. This one don't even. This is from TVC, no volume at all. The other one was better. Okay, let's try the other one again. Which channel is having sound? Because it's like all of them, they don't get sound. Let's see. Oh my God. Oh my God. Oh my God. Oh my God. This one have sound because all of them, their sound, they don't get sound. Oh, okay. This one have better sound. Hold on, guys. Let me bring this one that has really good sound.
The declaration returned of third respondent by the first March 2023 as the President-elect of the Federal Republic of Nigeria is invalid by reason of non-compliance with the provisions of the Constitution of the Federal Republic of Nigeria 1999 and the Electoral Act 2022. A declaration that, having regard to the joint ticket principle enshrined in Section 142(1) of the Constitution of the Federal Republic of Nigeria 1999, the withdrawal of the first respondent as the vice presidential candidate of the second respondent by operation of law amounted to automatic withdrawal and invalidation of the candidature of the third respondent as the presidential candidate of the second respondent for the presidential election conducted by the first respondent on the 25th day of February 2023. A declaration that arising from the invalidity of the third respondent nomination, the first respondent ought not to have included the name or the abbreviation of the name or the logo of the second respondent in the ballot papers and other election materials used by the first respondent for the conduct of the presidential election held on 25th day of February 2023. The fourth respondent was not qualified to contest as the vice presidential candidate of the second respondent as at 25th February 2023 when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 35 of the Electoral Act 2022. An order nullifying and voiding all the votes scored by the third respondent in the presidential election conducted by the first respondent on 25th February 2023 in view of his non-qualification as a candidate of the second respondent. Upon the ground of prayer 4 above, an order nullifying and/or setting aside the return of declaration of the third respondent as winner of the election conducted by the first respondent for the office of the President of the Federal Republic of Nigeria on the 25th day of February 2023, same having been made in violation of the provisions of Section 142(1) of the Constitution of the Federal Republic of Nigeria 1999 and Section 35 of the Electoral Act 2022. And finally, upon the ground of prayers 5 and 6 above, and in the absence of the third respondent's participation in the presidential election held on 25th February 2023, pursuant to Section 136 sub 2 of the Electoral Act, an order declaring the candidate with the next highest number of votes as the winner of the election. The grounds of the petition as set out in paragraph 15 of the petition is as follows. Your petitioner states that the ground upon which this petition is presented is that the third respondent was at the time of the election not qualified to contest the election. The respondents were duly served the petition and also responded by filing their replies. The first respondent reply to the petition was filed on 9th of April 2023. The second respondent reply to the petition was also filed on 9th of April 2023, while that of the third and fourth respondents was filed on 13th of April 2023. The fifth respondent also filed replies to the petition. On the 16th of April 2023, the petitioner then filed replies to the respective replies of the respondents to the petition. The respondent filed a number of motions, all of which challenge the competence of the petition. These motions were duly heard during the hearing session and rulings reserved. The first motion was filed by the first respondent. Applicant here in this motion was filed on the 6th of May wherein he sought the following reliefs. 1. An order striking out paragraphs 2, 3, 4, 5, 6, 7, 13, 14, and 15 of the petition reply filed on 20th day of April 2023 in response to the first respondent's reply. 2. An order striking out paragraphs 8, 9, 10, 11, and 12 of the petition reply filed on 20th of April 2023 in response to the first respondent's reply. And for such further orders as the Honorable Tribunal shall deem fit to make in the circumstance. We were urged to note that the grounds for the petition or for the application are as follows. They have been reproduced in the ruling. I need not read them out. So the motion is supported by an affidavit of 4 paragraphs and a written address. The petitioner respondent then responded by filing counter affidavit of 7 paragraphs on 13th of May 2023. Same was accompanied by a written address in opposition to the application. The arguments of counsel in respect of that application have been considered. Is here in the ruling. A similar application was also filed by the second respondent on the 8th of May 2023, wherein the second respondent prayed this court to grant the following reliefs. 1. An order of the Honorable Tribunal granting leave to the second respondent applicant to file and argue this application before or outside the pre-hearing session in this petition. It should be noted that this court is sitting as the Court of Appeal, not as a tribunal. So an order of this honorable court.
Did you hear that?
Paragraphs
Court of
1,
Appeal,
2, 3,
not
4,
as
5,
tribunal.
6, 7,
Hey.
8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 17 sub 1, 2, 4, and 5. Paragraph 18, 19, 20, 21, 22, 23, and 24 of Part D of the petitioner's reply and or the entire petition reply to the second respondent's reply to the petition for being an unnecessary repetition and or introduction of new facts unrelated to the second respondent's reply to the petition. 3. An order of the Honorable Court striking out in whole or part thereof of the witness statements on oath filed together with the petition reply to the petition for being irregular and in flagrant non-compliance with the relevant provisions of the first schedule to the Electoral Act 2022. The grounds for that application have also been summarized in this judgment, the same thing with the submissions of counsel. The third and fourth respondents also filed a motion on the 13th of May 2023, seeking the following reliefs. 1. An order striking out the entire reply filed by the petitioner on 20th April 2023, together with the accompanying witness statements on oath, list of witnesses to be relied on, and the list of additional documents. 2. Further, or in the alternative to prayer 1 above, an order striking out paragraphs 1, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, up to 21 of the petition reply under the heading Petition Reply to the third respondent's reply to the motion filed on 20th April 2023 to the applicant's reply to the petition, and for such further orders as this Honorable Court may deem fit to make in the circumstances. The grounds have also been referred to in this ruling. We have also considered the submissions of counsel. Now, it is apparent that the first respondent's motion filed on the 6th of May 2023, the second respondent motion filed on the 8th of April 2023, and the third and fourth respondent motion filed on 13th May 2023 are all aimed at having certain paragraphs of the petition replies to the respective replies of the respondent's replies to the petition struck out. The common ground in all the applications is that the averments in the petitioner's reply have introduced new facts, new issues, facts, and or grounds to the petition. Furthermore, that some of the averments are rehash or repetition of the averments in the petition file, that those averments in the petition replies offend paragraph 16, subparagraph 1A and B of the first schedule to the Electoral Act 2022. The said paragraph to the Electoral Act stipulates that
one important thing here. He said that the court is sitting as court of appeal, not a tribunal. Did you hear that?
If the petition has not dealt with, the petitioner shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, a petitioner reply in answer to the new issues of fact, so that A, the petitioner shall not at this stage be entitled to bring in new facts, grounds, or prayers tending to amend or add to the contents of the petition filed by him, and B, the petitioner reply does not run counter to the provisions of paragraph 14.1. In my view, the provisions of paragraph 16.1 of the first schedule to the Electoral Act 2022 are clear, unequivocal, and unambiguous. It does not, therefore, require any text to be understood. From a holistic reading of that provision, it will be seen that it is meant to explain the purpose of a petitioner's reply to the respondent.
Ajibola, Nsima, I can beg
answers to the defense
you. Obi is at the back of the camera at Arise channel discussing with
the effect of destroying the respondent's defense or make it not maintainable. The bottom line is that a petitioner is permitted by the first schedule to the Electoral Act 2022 to file a reply while the respondent to the petition has in his reply raised new issues of fact in the defense, which fact the petitioner has not dealt with in the petition. However, in doing so, the petitioner reply shall not introduce new facts, grounds, or prayers tending to amend or add to the contents of the petition. I've cited the case of APC and PDP citations applied. It is therefore clear that paragraph 16.1 of the first schedule to the Electoral Act does not permit a petitioner in his reply to introduce or bring in any new issue or fact which ought to have been raised in the petition itself. In other words, a petitioner cannot, in the guise of a reply to a respondent's reply, introduce a new issue or fact which was never raised in his petition nor raised by the respondent. To do that will amount to amending or adding to the petition and also taking the respondent by surprise, because at that stage the respondent will not be in a position to react to such new issue or fact. It will therefore breach the respondent's fundamental right to fair hearing. Therefore, the petitioner is not permitted to repair or rehash his averments in the petition in such a way that it will amount to an amendment.
So is there anything like Charlie Boy bus stop? Is it in Lagos? Somebody said that should be renamed. Very good.
With the state of the law as stated above, at the back of my mind, I have endeavored to scrutinize the proceedings in the respondent's respective replies to the petition. These are the specific paragraphs of the petitioner replies complaint of. I start with the first respondent complaint. The first respondent complaint is against paragraph 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and 15 of petitioner reply. I have carefully studied those paragraphs of petitioner reply. It's my view that paragraphs 1,
okay, so guys,
7, 8,
something
12,
has to
and
be
14
done.
of petitioner reply to the first respondent reply are competent, as they are proper replies to the first respondent's reply. However, paragraphs 2, 3, 4, 5, 9, 10, 11, 13, and 15 of the said petitioner reply are not competent, as they are either rehash or facts pleaded in the petition, or they introduce and or add new facts to the petition. Being incompetent, they are hereby struck out. The complaint of the second respondent is against paragraphs 1, 2, 3, 4, 5, 6, 7, 9, 10, 11, 12, 13, 14, 15, 16, 17, sub 1, 2, 3, and 4 and 5, sorry, 18, 19, 20, 21, 23, 25, part B of the petitioner reply to the second respondent's reply to the petition. I have carefully considered those paragraphs in the light of paragraph 16(1)A and B of the first schedule to the Electoral Act 2022.
Guys, why do we have Charlie Boy bus stop in Lagos? Why?
It is settled law that where a respondent raises in his reply to the petition fresh or new issues, it will be necessary for the petitioner to file a reply to the respondent's reply to the petition. At that stage, the petitioner may also file further written statements on oath of witnesses he may wish to call in rebuttal of the new issues raised by the respondent. This is because any failure by the petitioner to reply or answer to those new issues raised by the respondent will be deemed that the petitioner has conceded to start fresh on new issues. The cases of Idris and ANPP, Dingyadi and Wamako were also cited. That being so, the written statements on oath of witnesses filed along with the petition reply to the respondent reply in proof of the paragraphs struck out are accordingly struck out. In my view, paragraphs 1, 2, the paragraph listed of the petition reply to second respondent reply to the petition are either rehash of paragraphs in the petition or introduced or added new facts to the petition. They are incompetent and accordingly struck out. Also of the view that paragraphs 1, 3, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 to 20 of the petition reply to third and fourth respondent reply to the petition are rehash of the vermins in the petition. They are, in my view, incompetent and accordingly struck out. This other motion filed by the first respondent on the 7th of May,
they don't squash everything.
2023,
they don't throw one.
Seeking the following relief. One, an order of this honorable court striking out the petition for being incompetent and an abuse of court process. The grounds of for filing the motion have been produced. The motion is supported by 6 paragraphs, affidavit deposed to by 1, Give Nwadike, a litigation secretary in the law firm of Dikko and Mahmoud, solicitors to the first respondent applicant. It is also accompanied by a written address filed in support of the motion. In response, the petitioner filed a counter affidavit on the
They say the petition filed by Obi is an insult,
consisting of paragraphs
oh boy, you don't have
of 7 paragraphs, deposed by 1 Kalu Kenneth Okoye, litigation secretary in the law firm of Mrs. O.M. Atoyo B. SAN and partners. A written address was also filed along with the counter affidavit. Consider the arguments of counsel on this motion.
My brother, may they come on the street. Charlie Boy said they are coming on the street.
The third and fourth respondents
you don't see
also filed a similar motion on 12th of May 2023. Therein, the third and fourth respondent prayed for an order of this honorable court striking out and or dismissing this petition for being incompetent, fundamentally defective, and vesting no jurisdiction on this honorable court to adjudicate thereon. The grounds for the application have been listed.
You see, all the petitions say na insult to the court. Hey, it don't happen. Say, yeah. Sorry.
In this motion, several grounds were raised.
Sorry, oh. Sorry, oh. Sorry, oh. Sorry, oh. Sorry, oh. Obingos. Obingos. Sorry, oh. Sorry, oh. Obingo, sorry, sorry. You don't finish. Sorry, sorry. Obingo, sorry. My brother, they know they talk anything. They don't be. You don't hear them? It's an insult to the court. I don't even know how to describe it. And it's an appeal. When they shout in tribunal, 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 tribunal.
Now it is apparent that the sole ground of this petition is centered on the qualification of
and First of Keyamo already corrected them long time
ago. Respondent.
They said
the
they are
issue
coming
of
on the
qualification.
That is what Charlie Boy said. That is why I was asking about the bus stop. Why do they have Charlie Boy?
The issue of qualification or disqualification of a candidate to contest an election for the office of President of Nigeria is a constitutional one.
You know, we are the one
that is why it is stipulated in section 134, subsection 1.
If they want to destroy the country, why should we allow such people to be having bus stop?
Of the Electoral Act 2022 that an election may be questioned on any of the following grounds. A person whose election is questioned was, at the time of the election, not qualified to contest the election. The qualifications and or disqualifications of a candidate to contest an election for the office of president are stipulated in section 131 and 137 of the Constitution of the Federal Republic of Nigeria as amended. While the qualifications are inherent in section 131, the disqualifications are ingrained in Section 137, subsection 1A to J of the Constitution, supra. It is apparent, therefore, that the issue of qualification of a candidate to contest an election could be a ground in an election petition, though it may also ground a pre-election matter, where such issue of qualification or disqualification of a candidate arises from the primary election of the party by virtue of Section 285, subsection 14 of the Constitution. Where the issue of qualification or disqualification arises from before the election, it is an election, a pre-election matter, and an action on that issue must be instituted pursuant to Section 285, subsection 11 and 14 of the Constitution. It should be noted that upon a quick and careful perusal of the pleadings and in the petition, the issue of disqualification of the first respondent rests solely on the issue of the alleged invalid nomination of his running mate, to wit, the third respondent. The issue of invalid nomination is captured by paragraphs 18, 19, 20, and 21 of the petition. For proper understanding of the facts pleaded, those paragraphs have been produced. The second issue, arm of that issue is captured in paragraphs 22, 23, 24, and 25, and 26 of the petition. Considering the facts pleaded above, it is clear that the claim of disqualification or non-qualification disqualification, non-qualification with third respondent is centered solely on the invalid or double nomination of the fourth respondent. However, it is the settled law that the issue of nomination of a candidate at an election is a pre-election matter. Therefore, the issue of qualification or disqualification can only be ventilated on the grounds enumerated in sections 131 or 137 of the Constitution. That is why Section 84, subsection 3 of the Electoral Act 2022 stipulates that a political party shall not impose nomination qualification or disqualification criteria, measures, or conditions on any aspirant or candidate for any election in its constitution, guidelines, or rules for nomination of candidates for elections, except as prescribed under Section 65, 66, 106, 107, 131, 137, 177, and 185 of the Constitution. 187. It therefore means that the conditions of qualification or disqualification are prescribed by, under Sections 131 and 137 in case of person contesting for office of president. That means that where it is alleged in an election petition that a person is or was not qualified to contest election to the office of President of Nigeria, as stipulated in Section 134, subsection 1A of the Electoral Act 2022, it is Sections 131 and 137 of the Constitution of Nigeria that are applicable. See the cases of PDP and ANIC, Kaki and PDP, Ucha and Unwe, and Captain Idris, Ichala Wada and others, versus Yahya Bello and others, all citations supplied. That's why election has been conducted and result declared. Such election cannot be questioned on grounds of qualification under sections 131 and 137 of the Constitution in the case of a presidential election. This postulation is supported by Section 134, subsection 3 of the Electoral Act, where it is stipulated that with respect to subsection 1A, a person is deemed to be qualified for an elective office, and his election shall not be questioned on grounds of qualification if, with respect to the particular election in question, he meets the applicable requirements of Section 65, 106, 137, or 177 of the Constitution, and he is not, as may be applicable in breach of Sections 66, 107, 137, or 182 of the Constitution. As stated earlier, the applicable provisions are Sections 131 and 137 of the Constitution. It is clear from the plenitude of the pleadings in this petition that the facts grounding the petition's claim of disqualification or non-qualification of the third and fourth respondents is hinged on double and invalid nomination of the first respondent. I had pointed out earlier in the course of this ruling that the issue of qualification or disqualification of a candidate at an election is strictly a requirement of the Constitution. That it was held in the case of Al-Hassan and another versus Ishaku and others, citation supplied a court by virtue of the provisions of Section 138 sub 1A of the Electoral Act. The tribunal's power to decide whether a person is qualified to contest an election is restricted to establishing the requirements of Section 177 and 182 of the Constitution against the adverse party. An election tribunal has no jurisdiction to inquire into the primaries of a political party. Close of court.
They even say
it is apparent, therefore, that issues of nomination or sponsorship of candidates by political parties come under pre-election matters and should be instituted and determined before the conduct of the election. Shinkafi and others versus Yari and others, Ella and others versus Abo. That being so, a ground of election petition questioning the election of a person duly qualified to contest such election as required by the Constitution cannot be sustained where it is predicated on nomination or sponsorship of such candidate. Therefore, a petitioner who relies on non-qualification of his opponent to nullify the election must bring the facts of such non-qualification within the ambits of Section 131 and 137 of the 1999 Constitution. I have noted that the petitioner respondent sought to tie his complaint of non-qualification to Section 142(1) of the 1999 Constitution. That provision stipulates as follows. I quote, in any election to which the foregoing provision of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected to the office of vice president if the candidate for election to the office of president who nominated him as such associate is duly elected as president in accordance with the provisions of aforesaid. I am of the view that the above cited provision of the Constitution does not create additional qualifications or disqualifications for a candidate contesting for the office of president of Nigeria. Furthermore, Section 142 of the 1919 Constitution, read along with Section 141 of the said Constitution, create the office of President and Vice President. Section 142(1) is a specific provision donating power to the President to nominate a person as his associate to occupy the office of the President. That's why subsection 2 of Section 142 mandates that the requirements of qualification and disqualification attaching to the occupier of seat of President also applies to the holder of the office of Vice President. It is therefore my view that Section 142, subsection 1 of the Constitution does not introduce the issue of nomination or sponsorship of Vice President so as to enlarge the scope of qualifications or disqualifications applicable to the seat of President. There cannot therefore be a disqualifying factor of a candidate for the office of President outside those specified in Section 131 and 137 of the Constitution. It can safely be said that those provisions have sufficiently and conclusively covered the field until there is an amendment to the Constitution. See the cases of AG Abia and AG Federation, also PDP and ANI Supra. As a fallout to my findings above, I hold the firm view that the issue of nomination or sponsorship for the respondent, being a pre-election matter, ought to have been ventilated by the petitioner before the Federal High Court, as this court has no jurisdiction to delve into the matter. Even if this court has such jurisdiction, the course of action being a pre-election matter is statute barred by virtue of Section 285, Sub 9 of the Constitution of the Federal Republic of Nigeria 1999 as amended. Having found as above, it is my view that the two motions filed by the first respondent and third and fourth respondents on 7 May 2023 and 12 May 2023, respectively, have no merit. Accordingly, I find that the petition is have merit. Accordingly, I find that the petition is liable to be struck out for being incompetent.
The petition
by a motion on notice filed on the 8th of May 2023, the second respondent, Dr. Appleton, sought the following relief.
This in the sweet.
An order of this Honorable Tribunal granting leave to the second respondent applicant to bring and argue this application before, or outside, or during the pre-hearing session. 2. An order of this Honorable Tribunal striking out grounds 1 and 2 contained in paragraph 16 of the petition for being incompetent. 3. An order of the Honorable Tribunal striking out paragraph 17, 18, 19, 20 to 29 of the petition, which are predicated on the incompetent grounds 1 and 2 in paragraph 16 of the petition for being an abuse of court process.
It's an abuse of court process.
An order of this tribunal striking out reliefs 1 to 7 of the petition's petition for being incongruous, illogical, and ungrantable.
I want to be writing out this.
And 5, an order of the Honorable Tribunal
I'm not a lawyer.
dismissing or otherwise striking out the petition for one of jurisdiction and on the ground that the petition does not disclose any reasonable course of action. Here's the grounds stated here in.
Hey, but this court, finish Obi, finish all of them, finish the thing, finish Obi, finish Atiku, finish all of them. All the petition incongruous. What is it? They say is incongruous, lacks merit, is an insult to the court. Hey, incongruous. God, let me don't forget that word. Incongruous.
I've considered the arguments of counsel which I've summarized in this ruling.
This stolen man, they can I bet who they sell handkerchief. Incongruous.
It will be seen that this application is premised on several grounds. The first is that the grounds of the petition are incompetent. This is premised on the erroneous argument of the second respondent or applicant that the grounds for the petition are as stated in paragraphs 16 of the petition. A careful perusal of the petition will disclose that there is only one ground for the petition and is stated in paragraph 15 of the petition as follows: that your petitioner states that the ground upon which this petition is presented is that the third respondent was at the time of the election not qualified to contest the election. The averments in paragraph 16 as unequivocally captioned deal with the facts of the petition. This ground for the objection to the competence of this petition therefore lacks substance and it is accordingly discountenanced. The second ground for the objection is that the petition is an abuse of court process. It is premised on the fact that the petitioner respondent had earlier instituted an action before the Federal High Court in suit number FHC/ABG/CS/1215/2022 between Allied People's Movement and INEC and 12 others on the same subject matter as in this petition against the first, second, third, and fourth respondents in this petition and others. It was, however, deposed in paragraph 3M of the counter affidavit filed by the petition in opposition to this application that the matter was not determined on the merit by the trial court, who referred the matter to the Court of Appeal for interpretation. That in any case, the matter had since lapsed in 180 days for determination by law, being a pre-election matter. It is tried law that abuse of court or judicial process simply means the use of court process malafide or in bad faith to the annoyance of the opponent. One variety of it is the institution of multifarious actions between the same parties with regard to the same subject matter and same issue in the same or another court. A quick look at the originating summons in suit number FHC-ABG/CS/1275/2022 will show that same was instituted in the Federal High Court, Abuja, on 27th day of July 2022. Being a pre-election matter, it ought to have been determined within 180 days, as required by Section 285, subsection 10 of the 1999 Constitution. It therefore means that it lapsed by January 2023, about a month the election in question was conducted. This petition having been instituted on the 20th of March 2023, when suit number FHC was no more alive, does not qualify as an abuse of court process. This ground for this objection is also discountenanced. On whether this petition is caught by the doctrine of estoppel, it was argued that the issues raised in this petition have been firmly resolved by the Court of Appeal in Appeal number CS/ABG/CS/08/2022. Issue estoppel arises when the issue has been decided upon to finality by a court of competent jurisdiction. In other words, once an issue has been raised and distinctly determined between the parties, another party can be allowed to fight that issue all over again. The same issue cannot be raised by either party again in the same or subsequent proceedings except in special circumstances. For issue estoppel to apply, the following conditions must be satisfied. A, the question must have decided, the same question must have been decided in both proceedings. B, the decision which creates the estoppel must be final, and the parties to the judicial decision or their previous to the proceedings in which the estoppel is raised must be the same. To determine whether the above three elements exist, the court will closely examine the reasons for the judgment and other relevant facts that were actually in issue in the proceeding. See the cases of Oyekola and others versus Amodu, OSPM Limited versus Nibel Company Nigeria Limited, and Dasuki retired versus Federal Republic of Nigeria Sanitation Supply. I have studied the case sought to be relied on as estoppel in this case. It is apparent that the parties in that case are not the same as in the instant petition. The issues, though the same, were not resolved to finality in the previous case. The action was struck out on ground of lack of local standard by the lower court, which this court affirmed on appeal. Thus, the objection on that ground is also discountenanced. On whether the question is statute barred, I had held in the earlier motion filed by the first respondent on 7th May 2023 and third and fourth respondent's motion filed on 12th May 2023, which were taken together. This petition, which is premised on the nomination or sponsorship of the fourth respondent, is a pre-election matter. That being a pre-election matter, it ought to have been instituted and ventilated by the petitioner before the Federal High Court within 14 days from the date of recurrence of the event or action complained of. That not having been done, the course of action in this petition stands barred by virtue of Section 2859 of the 1919 Constitution of the Federal Republic of Nigeria as amended. On the issue of local standing, I had also held in the previous motions filed on 7/5/23 and 12/5/23 that issues of nomination or sponsorship of candidate by political parties for an election come under pre-election matters. It is settled that the issue of nomination of candidates by substitution is purely a pre-election matter. The only person with the local standing to challenge the nomination is an aspirant who participated in the process of such nomination. In other words, apart from an aspirant who took part in the primary election, no other person is authorized to challenge such nomination by a political party for an election. Such process of challenging the nomination is sanctioned by Section 84, subsection 14 of the Electoral Act 2 and 285, subsection 14 of the Constitution.
My brother, I don't hear so many grammar today.
Kafi and another Abdul Aziz Eyari and Al Hassan another and Ishaku. It therefore follows that the course of action in this petition, which is rooted in the nomination or sponsor of the fourth respondent, is a pre-election matter. Being a pre-election matter, the petitioner herein has no local standing to challenge or question such nomination.
Exactly, pre-election matters.
By the second respondent. Thus, in People's Democratic Party (PDP) and Independent National Electoral Commission and others, unreported decision of the Supreme Court, delivered on 26th day of May 2023 in SC/CV/501/2023. I had the matter has been reported, but I have not been able to avail myself of the report. Held at the Supreme Court held at page 71 page 31 lines 1 to 16 thereof as follows. Court, the provision does not make the filing of pre-election matters by political parties an all-comers affair. It is not the purpose of the provision that the floodgate of pre-election litigation be open to political parties who will hide under it to challenge the actions or inactions of rival political parties of challenging the decision or activities of INEC. The application of Section 285, Section 14C of the Constitution does not extend to a political party poking into the affairs of another. The position of the law has always been that no political party can challenge nomination of the candidate of another political party. no matter how pained or disgruntled a political party is with the way and manner another political party is conducting or has conducted its affairs concerning its nomination of its candidates for any position, it must keep mum and remain an onlooker, for it lacks the local standing to challenge such nomination in court, close of court. It is clear, therefore, that a political party such as the petitioner herein only has the local standing to file a pre-election matter when the situation affects it or its candidate by virtue of Section 285, Section 14C of the 1999 Constitution. That being so, as in the instant petition, where the grounds of the petition is rooted on the nomination or sponsorship of the candidate of another political party, this petitioner will have no local standing to institute the action, be it in the Federal High Court or an election tribunal. For that reason, it is my view that the course of action in this petition being on the nomination and sponsorship of the third and fourth respondents by the second respondent applicant, the petition is incompetent for lack of local standing on the petition to institute the action.
The petition is incompetent, what the local standing?
Incompetent.
Oh boy, the English. Ah.
The second respondent applicant also contended that the petition is not properly constituted as the candidate sponsored by the petitioner has not been joined as co-petitioner in the petition. The short answer to that is that Section 133, subsection 1B of the Electoral Act 2022 entitles a petition as a political party to institute an election petition. The applicant has not referred us to any provision of the Electoral Act or any authority that mandates the political party to file an election petition only when its candidate has been joined.
The team is already on ground now in Abuja. All of them are singing.
It is proper for the candidate of the party to be so joined, but there is no law that compels the political party to join its candidates in the petition. After all, the purpose of such joinder is so that the candidate can be bound by any judgment or order of the court or tribunal, but any non-joinder will not invalidate the petition. This is particularly so when Section 133, subsection 1 of the Electoral Act stipulates
the gyration is going on.
An election petition may be presented by one or more of the following persons: A, a candidate in an election, or B, a political party which participated in the election. By the use of the disjunctive word "or" means that an election petition may be filed by the candidate alone or the political party alone.
I told you that the patriotic Nigerians will be on the street.
The objection on this ground is also discontinued.
Noisemaker.
By another motion filed on the 15th of May 2023, the fifth respondent, Das Kabir Masari, prayed this court to grant him the following reliefs. 1. An order of this court dismissing this petition in its entirety for want of jurisdiction. 2. An order striking out the name of the fifth respondent applicant from this petition for non-disclosure of any reasonable course of action against him. And first, other orders as this honorable court may deem fit to make in the circumstances. The grounds for the application have been...
I said this time around, we are not going to allow...
States have also...
Patriotic Nigerians will be on...
Considered the submissions of counsel. Now, Section 133. Section 133 of the Electoral Act defines persons who are necessary parties in an election petition. Generally, necessary respondents in an election petition are the persons whose election or return is complained of and the electoral body that conducted the election. This is Section 133, subsection 2 and 3 of the Electoral Act 2022. Those are what are termed statutory respondents. It should be remembered that election petitions are sui generis, are sui generis and its procedure is strictly regulated by statute. That's why a person does not fall within the category of statutory respondents. They are not registered parties in an election petition. See the cases of Agbere and Mimra, Buhari and Yusuf, APC and PDP. That's in Waziri versus Gaidam. The Supreme Court held, I quote, "From the above, I have no difficulty in going along with the submissions of the respective counsel for the respondents. that Section 137 sub 2 and 3 of the Electoral 2020 has no room for the joinder of the fifth respondent who neither won the election nor performed any role as electoral officer or agent of the third respondent in the election petition, challenging the result of such an election. And even no relief was claimed against the said fifth respondent, and indeed, he had nothing to gain or lose in the petition aforesaid. Close of court. Indeed, a holistic reading of the facts of this petition does not disclose any complaint against the fifth respondent. The only fact that relates to the fifth respondent relevant to the petition is the act of withdrawal of his candidacy as the running mate of the third respondent. That is an act that occurred within the pre-election period, therefore cannot amount to any act done by the fifth respondent at the election. It cannot therefore ground any complaint by the petitioner against the fifth respondent in an election petition. It may be relevant in a pre-election matter, but not in an election petition. It is therefore my finding that there is no any claim on the fifth respondent. In other words, the relief sought in the petition will not in any way affect the fifth respondent, as he did not participate in the petition either as a candidate or agent of the second respondent, and no declaration was made in his favor by the first respondent. In that respect, I hold that the objection of the fifth respondent on this ground has merit. Finally, I order that the name of the fifth respondent is struck out of this petition. These are the rulings.
All the petition, they have no ground, they are incongruous, they have logo standing.
I will now go to the
my God.
Main petition itself. So after the pre-hearing session, hearing on the petition opened and closed on the 21st of June 2023, the petitioner called one witness and closed his case. None of the respondents called any witness, but tendered some documents from the bar, and the petition was adjourned for adoption of written addresses. Parties then filed and served written addresses as directed by this court, and same were adopted on the 14th of July 2023. The matter was then adjourned for judgment. The first respondent's written address was filed on the 30th of June 2023. Therein, 4 issues were raised for determination as follows. 1, whether considering the facts of the petition and evidence laid thereon, the petitioner has the local standing to question the nomination of the first respondent as a ground of challenging the qualification and the return of the third respondent as the winner of the presidential election of 25th February 2023. 2, whether having regard to the facts pleaded and evidence laid thereon, vis-a-vis the provision of Section 134, subsection 3 of the Electoral Act 2022, can the issue of validity of the nomination of the first respondent as the vice president candidate of second respondent be validly raised as a ground before this honorable court to question or challenge the qualification and return of the third respondent as the winner of the presidential election of 25th February 2023. Number 3, if the answer to note 2 is in the affirmative, whether having regard to the facts pleaded, the nomination of the first respondent as the vice president candidate of the second respondent is void, as to render the third respondent not qualified to contest the presidential election of 25th February 2023. 4, whether considering the relief sought as per the petition accrues no utilitarian benefit to the petitioner, this petition not an abuse of court process. Well, to save time, all the other respondents filed briefs and raised issues. These issues have been produced in this judgment, including the issues raised by the petitioner.
Alpha, Obi Gererenge, LOP 7000. Alpha, Gladys Amaka Uti say no one is going to cry because you and your group had already rigged your way to the presidency. We love it. I want you to know that everyone will collect in this bad government, whether you are outside Nigeria or within. Get out. You are not turning. You are changing your mouth. I thought you people say that you are the one that won. It don't happen. Get out of here. Nonsense.
Now it is apparent from the averments in the petition, the oral and documentary evidence, and the submissions of counsel that this petition is grounded on the disqualification of the third respondent to have contested the presidential election of 25th February 2023. This is evident in paragraph 15 of the petition, there, wherein the petitioner pleaded thus. I had read it earlier. This is further explained as emanating from the non-qualification of the first respondent to have contested the election as the vice president candidate of the second respondent. It is specifically pleaded in paragraph 17 of the petition as follows. Your petitioner states that the fourth respondent was not qualified to jointly contest with the third respondent for the presidential election held on 25th February 2023, having been purportedly nominated by the second respondent as its candidate for more than one office. The specific reasons for questioning the qualification of the third respondent have been pleaded in paragraphs 16.1 and 2 of the petition as follows. Those paragraphs have been reproduced. If you get the judgment, you will see it.
Your OB has been attending
so a combined reading of paragraphs 15, 16, and 17 of the petition, coupled with the particulars thereof, show clearly that the petition is premised on non-qualification of the third, fourth respondent. I find it necessary to state that the grounds for questioning the return at an election are stipulated in section 135, subsection 1 of the Electoral Act, that has been reproduced earlier. For the purpose of this petition, it is the ground stipulated in section 134(1)(a) that is relevant. In other words, the election of the third and fourth respondent as president and vice president is questioned on the ground that they are not qualified to have contested the said presidential election. I've considered paragraphs 18, 19, 20, 21, 22, 23, 24, 26, and 28 of the petition as relevant for the termination of the petition, which paragraphs have been reproduced in this judgment. In response, the first respondent, that's INEC, filed a reply to the petition where it was averred in paragraphs 14, 15, and 16 of the first respondent reply to the petition as follows, which has also been reproduced. The second respondent also filed a second reply to the petition and also averred in one of 16, 20, 21, 22, 23, 24, 25, 26, 29, which have been produced herein. So from the totality of the pleadings in the petition and the replies of the respondents, what appears from the complaint of the petitioner is that the fourth respondent, while still a candidate of the second respondent for Borno's Central Senatorial District, was nominated and did accept to be the vice president candidate of the second respondent. That this act violated the provision of Section 35 of the Electoral Act 2022 as it amounted to his double nomination. That in the circumstances, his nomination as an associate of the second respondent for the presidential election is void. That the result is that the third respondent was disqualified from contesting the election because he did not have a validly nominated running mate at the time of the election. The petitioner relied on Section 131 and 142(1) of the 1999 Constitution for his postulation. Section 131 and 142 sub 1 of the Constitution of Federal Republic of Nigeria as amended stipulate as follows. A person shall be qualified for election to the office of president if A, he is a citizen of Nigeria by birth, B, he has attained the age of 40 years, C, he is a member of a political party and is sponsored by that political party, and D, he has been educated up to at least full certificate level or its equivalent. 142(1). In any election to which the foregoing provision of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running mate for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected to the office of vice president if the candidate is for election to the office of president who nominated him as such associate is duly elected as president in accordance with the provisions aforesaid. The general principles of interpretation of the Constitution
is duly elected. My brother, everything is gone.
Mere technical rules of interpretation of statutes are to some extent be avoided in a way as not to defeat the principles of government. That's why the words used are clear and unambiguous. A literal interpretation should be applied. In the interpretation, therefore, the provisions of the Constitution are to be accorded holistic interpretation so as to avoid ambiguity and arrive at the true intention of the legislature. The court must limit itself to the words used in the Constitution without resort to any external aid or materials. In the cases of Sani and President Federal Republic of Nigeria, Amadi and Ani, and Agi and PDP and others. Thus, in Wike Ezonwo Nwesom, Honorable Dr. Atiku, Adol, Peterside, and others, the Supreme Court observed that, quote, the principle of conception of the Constitution to the effect that a Constitution is a living document, not just a statute, providing a framework for the governance of a country, not only for the present, but for generations yet unborn. It was held that in construing the Constitution, undue regard must not be paid to merely technical rules, because in doing so, the objects of the provisions as well as the intention of the framers of the Constitution will be frustrated. Courts have always been encouraged to adopt a broad and liberal spirit in interpreting the provisions of the Constitution while constantly bearing in mind the object which such provisions were made to serve, close of court. That being so, where the Constitution has stipulated the qualifications to be attained by a person contesting or seeking to contest for any elective office created by the Constitution, the courts cannot create or import into the Constitution any other qualifying or disqualifying factor. This has been the position of the Supreme Court and dutifully followed by this court. It has therefore been held that qualification or decision of candidates to contest election is exclusively determined within the context or scope of the Constitution, and that nothing can be added to it. In other words, the Constitution, being the ground norm, is superior to any other law, including the Electoral Act. Therefore, where the Constitution has qualified a person or candidate to contest an election, no other law except the Constitution itself can disqualify him. The petitioner in this case has premised his complaint of non-qualification or disqualification of the third and fourth respondents as the president and vice presidential candidates of the second respondent on the issue of invalid nomination of the fourth respondent. That the fourth respondent, while still the senatorial candidate of the second respondent for the Borno Central District, allows himself to be nominated as the vice presidential candidate of the second respondent for the same election. In our rulings earlier delivered on the motions and preliminary objections, we had ruled that the petition grounded solely on the issue of invalid nomination or improper nomination is not a cognizable ground of disqualification under the Constitution. In other words, the claim in the petition that the third respondent was not qualified to contest the presidential election because he nominated an associate whose nomination was invalid does not flow from any ground of disqualification of a candidate to the office of president as stipulated in section 131 and 137 of the 1999 Constitution. See the cases of Balewa and Mwazu and Faleke and Anik, Tazu versus Yorea. Then in Shinkafi versus Yari, the Supreme Court held that the Supreme Court has listed in section 182, section 182 very exhaustively all the issues that can qualify a person from contesting the office of governor of a state. From the record of this court, the facts have not disclosed any evidence to show that the first respondent was not qualified to contest elections into the office of governor of Zamfara State. It is my view that once a candidate sponsored by his political party has satisfied the provisions set out in section 177 of the Constitution and is not qualified under section 182 subsection 1 thereof, he is qualified to stand election to the office of governor of a state. No other law can qualify him. This authority can apply mutandis to section 131 and 137 of the Electoral Act. It has not been contended by the petitioner that either the third or fourth respondent is termed by the provisions of Section 131 or 137 of the 1999 Constitution.
No one.
The complaint of the petitioner rooted on nomination and suspension of third and fourth respondent will find accommodation in a pre-election dispute, which the petitioner cannot even pursue, not being a member of the second respondent. This Section 84, subsection 14 of the Electoral Act 2022 and 285(14) of the Constitution. While I'm tempted to put an end to this petition at this stage, but realizing that this court is not the final court on the matter, I'm constrained to look at the merit of the petition. As pointed out earlier in the course of this judgment, the complaint of the petitioner in this petition is that the third respondent was at the time of the presidential election held on 25th February 2022 not qualified to contest the election. This is because, according to the petitioner, the fourth respondent was not qualified to run on a joint ticket with him, that's third respondent, as the fourth respondent nomination was invalid for double nomination, which violates Section 55 of the Electoral Act 2022. As stated earlier, the petition contended that the fourth respondent was a candidate of the second respondent for the Borno Central District when the third respondent nominated him as his vice presidential candidate on the 14th July 2022. In other words, that at the time the fourth respondent was nominated, he had accepted nomination as the vice presidential candidate of the second respondent. He was still a validly nominated central candidate of the second respondent for Borno Central District. The petitioner then contended that the second respondent had earlier submitted the name of the third respondent together with that of the fifth respondent as his presidential and vice presidential candidates for the 25th February 2023 election. However, that before the date of the election, the fifth respondent withdrew his candidature as the running mate of the third respondent on the 24th June 2023, and the name of the fourth respondent was then submitted to ANIC, that's fifth respondent, on the 15th July 2022. That the second respondent did not conduct any fresh primary election for the purpose of picking another running mate for the third respondent after the withdrawal of the fifth respondent. The respondents conceded that the fourth respondent was ab initio the central candidate of second respondent for Borno Central District. However, that on the 6th July 2022, the fourth respondent via a letter dated the same date notified his political party, that second respondent, of his withdrawal from the central candidature. That upon receipt of the fourth respondent letter, the second respondent immediately notified ANIC, and which notification letter was received on the 13th July 2022. That the same letter also notified the first respondent of its intention to conduct a fresh primary election for the replacement of the first respondent following his withdrawal as a central candidate. That it was until 14th July 2022 that the first respondent was nominated as the third respondent associate for the presidential election of 25th February 2023. The fifth respondent notice of withdrawal as a candidate is in evidence as Exhibit PA2, while the notice of withdrawal and letter of voluntary withdrawal of the fourth respondent are in evidence as Exhibits PA3 and PA4 respectively. It will appear that the petitioner is the view that the fourth respondent was still the central candidate of the second respondent as at the 14th of July 2022, when the fourth respondent was nominated as the vice presidential candidate of the second respondent. However, the respondents contended that the issue of alleged double nomination of fourth respondent has been determined finally by the Supreme Court in People's Democratic Party, PDP versus ANIC, that in the circumstances, the said judgment of the Supreme Court constitute estoppel parem judicata and binding on the parties in this petition. Now, for a judgment to constitute issue estoppel, the conditions are earlier stated in the rulings. So the three elements must be present and coexist for a plea of estoppel parem judicata to apply. In the cases of Ito and Epe and others, Oshoboja versus Amida and others, and Alexandra and others versus Lone Star Drilling Company Limited, all citation supply. It is obvious that the judgment sought to be relied on for the plea of estoppel is that of the Supreme Court, the highest and final court in this country. There is no doubt that the decision was final and the issue that was thrown court is the same as in the present petition, with whether the fourth respondent breached Section 35 of the Electoral Act but by allowing himself to be nominated in more than one constituency. The petitioner has, however, argued that the issue decided by the Supreme Court was merely on the local standing of the PDP to question the nomination of the fourth respondent, the candidate of the APC, a different political party. That may well be so, but it is clear from the judgment, thus Exhibit X1, that the Supreme Court pronounced on the substantive issue of double nomination. Though Joro JSC, who delivered the lead judgment, declined to exercise the powers of the Supreme Court under Section 22 of the Supreme Court Act to pronounce on the merit of the case, the other laws of the Supreme Court proceeded to do so. It is settled law that a contributory or concurrent judgment has equal weight as the lead judgment. It is part of the lead judgment and therefore has the same force and binding effect. The mere fact that a concurring or contributory judgment contains what is not in the lead judgment will not whittle down its binding effect. Thus, in Olu, Eba, and others,
Somebody has to wear my cap. My brother, calm down.
my Lord Fabi JSC, court. The concurrent judgment has equal weight with or as a lead judgment. A concurrent judgment complements, edifies, and adds to the lead judgment. When the justice adds its certain aspects, which the writer of the lead judgment did not remember to deal with. Insofar as the concurrent judgment performs same for all the above functions, it has equal force with or as the lead judgment, insofar as the principles of the stare decisis are concerned.
You understand me? We don't tell them already.
Now it is apparent that the parties in Exhibit X1, PDP and ANI and other Supra are not the same as in the present petition. The earlier decision, though, involved the first, second, and fourth respondents. The present petitioner was not a party in that case. That is why it was argued by the petitioner herein that Exhibit X1 cannot operate as to stop it from litigating the issue of dominant nomination of the fourth respondent. The response have responded that the judgment in PDP and ANI Exhibit 1 is a judgment in rem as opposed to judgment in personam. In law, a judgment in personam is a judgment against persons who are parties or previous to the particular suit or proceeding alone. It is referred to as judgment inter partes. It is a judgment binding on the parties to the action alone. Judgment in rem, on the other hand, is a judgment that determines the status of a person or thing as distinct from the particular interest of a party to the litigation. It is referred to as judgment contra mundum, binding on the whole world. It is therefore binding not only on the parties to the dispute, but even non-parties. Therefore, once the status of a person or thing has been pronounced upon by a court of competent jurisdiction, no person is permitted to assert the contrary of what that court has decided. The Black's Law Dictionary, 11th edition at page 1008, Demishola versus Bolarinwa, Yanati Petrochemical Limited and EFCC. Then Ladi Jobi and others versus Oguntayo and others, partition supply. It is no doubt that the judgment matter in PDP and INEC others X1 was in respect of the alleged double nomination of the first respondent as the vice president candidate of the second respondent in the 25th February 2023 presidential election. That is the same issue raised in this petition as grounding the disqualification of the third and fourth respondent in this petition. Pronouncing on this issue in this case, in the contributory judgment, my Lord Okoro JSC, who presided on the panel of the Supreme Court, held as follows. There is no doubt that the fourth respondent was at the stage nominated as a candidate representing Borno Central District. But upon being muted, he would pair with the third respondent as vice presidential candidate of second respondent, All Progressive Congress, APC, in the 25th February 2023 general election. He withdrew his candidature for the Senate before taking up the position of vice president candidate. Documents in the record attest to this fact. These are APC 1, APC 2, which were made on the 6th and 10th of July 2022, respectively, those of court. After considering those documents, the Lordship concluded at page 7 of the control judgment that it is crystal clear that the two exhibits alluded to above, the fourth respondent did the needful by resigning his position of Senate candidate for Borno Central District since 6
And
July
they chop IPOP.
2022,
And they chop OP.
before being nominated by the third respondent to run alongside him as vice presidential candidate of All Progressive Congress. Another after citing Section 31 of the Electoral Act 2022, held at page 8 of his judgment at the court. The above provision of the Electoral Act 2022 was duly complied with by the respondent.
I mean, not see what
My
they do
well-considered
for the party.
opinion that as at the 6th of July 2022, having withdrawn his nomination and personally served him on the second respondent
When you wake up,
of the withdrawal
you realize
of
what I'm
nomination
telling you.
of
It's whether you like me or you don't
22,
like me.
2022, first respondent was no longer a candidate for the Borno Central District election, and his subsequent nomination as vice presidential candidate of the second respondent for the presidential election was not multiple nomination, as there was no longer a nomination for the first respondent.
Remember, the city boy is in India.
On the 6th of July 2022. I have also cited the elaborate contribution of his lordship, Ajim J. So I have endeavored to quote extensively the dicta of the laws of the Supreme Court in PDP and INEC Supra in order to show that the issue of double or even multiple nomination of the first respondent as the central candidate and vice presidential candidate of second respondent in the 25th February 2022 general election has been settled to finality. The judgment in rem, therefore binding on the parties to this petition and in fact the entire world, including this court. Being the judgment of the final court of the land, of this land, no person is permitted to again raise and litigate on it in any other action or proceeding. It is therefore settled and remains settled that this petition, which questions the qualifications and seeks to disqualify the third and fourth respondents from contesting and occupying the seat of president and vice president of Nigeria on ground or multiple nomination of the first respondent and vice president candidate of the second respondent on ground of double or multiple nomination of first respondent has no substance. I only wish to add that Section 35 of the Electoral Act is targeted at the candidate and not the political party. That is why it uses the terms a candidate and normally allows himself to be nominated by more than one political party or more than one constituency. That's to prove that the candidate knowingly allows himself to be so nominated. Both the intent and actual acts of nomination, that is, the mens rea and actus reus of the act prohibited must be proved, the stipulation in the section being a penal provision. In the instant case, neither the intent nor the fact of the first respondent to allow himself to be so nominated was established. That's why His Lordship Ogumi JC, in his contributory judgment, in Exhibit X1, held as follows, I quote, by Section 31 of the Electoral Act, the first respondent, Shetima, was obliged to submit a notice of withdrawal in writing to his party, which he did, and then his party is to deliver that notice to the Commission not later than 90 days to the election. In view of the above stated position of the law on this issue and the facts of this case, there exists no animus or display of intention by the first respondent to stand as the nominated candidate of the second respondent for the vice presidential position and also the senator representing Borno Central District in the general election of 25th February 2023. There cannot be any other interpretation of the circumstances unless there is clear intention to knowingly stand as a candidate for two elective posts in the same election cycle. Jim JC also contributed as follows, quote, the manifest intention to relinquish the earlier nomination to pay for the nomination of another person to replace him as the party's central candidate cannot be overlooked or disregarded. To simply isolate the assumed or purported short-lived coexistence of the two nominations for treatment as multiple nomination without regard to the obvious intention of the first respondent not to be the party's candidate in elections in two constituencies is against the legislative intent of Section 35 of the Electoral Act 2022. The sequence of the occurrence of the events is not what determines the existence of multiple nomination. It is the intention, design, or purpose to hold two or more nominations as candidate for election that shows that the persons who are nominated knowingly did so. The second respondent did not intend the first respondent. should be its candidate for Borno Central election and its vice presidential candidate for the presidential election. The first respondent did not understand or know that he was so nominated. The word knowingly in Section 35 of the Electoral Act must be interpreted broadly to include all its literal meanings. Barton's Legal Thesaurus, fourth edition by William C. Barton at page 356, is defined to include advisedly, deliberately, designedly, intentionally, learnedly, pointedly, purposefully, with knowledge, etc. It is clear to me, therefore, that from the oral and documentary evidence adduced by the parties on this petition, the intention and fact of knowingly allowing himself to be nominated in more than one constituency as alleged by the petitioner against the first respondent is not be established.
Calm down.
In other words, both the mens rea and actus reus of the act prohibited by Section 35 of the Electoral Act 2020 were not established. One other aspect alleged by the petitioner on its claim of invalid nomination of the third and fourth respondent is that the second respondent did not comply with Section 33 of the Electoral Act in the nomination of the first respondent as vice presidential candidate. That after the withdrawal of the fifth respondent, the second respondent should have conducted a fresh primary election within 14 days for the purpose of nominating a new vice presidential candidate. Now, Section 33 of the Electoral Act stipulates that a political party shall not be allowed to change or substitute its candidate whose name has been submitted under Section 29 of this Act, except in the case of death or withdrawal by a candidate, provided that in the case of such withdrawal or death of a candidate, the political party affected shall, within 14 days of the occurrence of the event, hold a fresh primary election to produce and submit a fresh candidate to the Commission for the election concerned. The interpretation of this provision does not, in my view, cause any difficulty as to require the application of any technical rule of construction. Therefore, a literal interpretation will suffice. It therefore means that where a political party has submitted the name of a candidate pursuant to Section 29 of the Electoral Act supra, it cannot be allowed to substitute or change that candidate except in the event of death or withdrawal of such candidate. By the proviso thereto, the political party affected is enjoined to conduct a fresh primary election for the purpose of producing a new or fresh candidate to submit to the Electoral Commission. The grounds of the petitioner here is that the fifth respondent withdrew his nomination as vice presidential candidate of the second respondent, but the second respondent did not conduct another primary election for the purpose of producing a new vice presidential candidate within the 14 days prescribed by Section 33 of the Electoral Act. It should be remembered that by Section 142, subsection 1 of the 1999 Constitution, a presidential candidate for election to the office of president has the sole discretion, authority, or power of nominating his associate who shall run with him in the election as vice president. The choice or nomination of vice presidential candidate is not the product of any primary election. Therefore, in my view, the requirement to conduct a fresh primary election does not apply to the nomination of a vice presidential candidate. Thus, my Lord of GJC alerted this point in its 1 as follows. The fourth respondent was not required to buy any nomination form. He was the second respondent, APC's candidate, at the election into the office of Senator representing Borno Central District. But before the election could hold, he was nominated as the third respondent's associate, who is to occupy the office of vice president. The fourth respondent did not buy a nomination form for the said office, and most importantly, did not contest any primary election in order to emerge as APC's vice president candidate.
They know how to run their propaganda.
The petitioner in paragraph 28.2 of his petition had averred and also contended in his final address that there was a gap of about 3 weeks between the period the fifth respondent expressed his intention to withdraw and his actual withdrawal or purported nomination, thereby invalidating the nomination of third respondent, because the candidature of the third respondent had lapsed and was no longer in a position to constitutionally nominate a running mate. This contention of the petitioner is, however, misconceived. There is nothing in the Constitution which robs a presidential candidate of his right to nominate his associate, who shall be his running mate for the office of president. There is also nothing that invalidates the nomination of a new associate by a presidential candidate as his running mate after the withdrawal of a previous associate, so long as the nomination of the new associate was submitted to the first respondent 90 days before the election as mandated by Section 31 of the Electoral Act 2022. This contention of the petitioner is therefore discountenanced. It is therefore my view that, that the position of a person as vice presidential candidate not being subject to primary election, the provision of Section 33 of the Electoral Act 2022 does not apply. On that note, I hereby hold that the petitioner failed to prove the lone ground of his petition to the effect that the third and fourth respondents were not qualified to contest the election held on 25th February 2023 for the reason of double nomination. Having resolved the sole issue of this petition against the petitioner, this petition held to be devoid of any merit.
Oh boy, this judge sabi speak English. Oh. He's from the north. Oh. I think they thought say people way from north, they don't sabi speak. They don't know anything. Hey, God of gods. The judge really scatter everything. English, book for here. Oh boy. I never see anything. I never see anything. Look at Shetima, they laugh. You see Shetima? see. You dey see her? Oh boy, they squash everything. All the English finish for here today. This is a northerner who is the judge. You dey see the English? He dey scatter everything. They thought say they no go school, abi? Una dey run on a propaganda they go. Now una go tire. You see what I tell you now? The thing wey una go suffer, una no go understand. Hey. No be prayer, so now the thing una they do una self be that. You don't finish now. Which other thing they want to talk again? Court supposed to court dismiss. Court dismiss. Hey, Shetima just smile. Say, oh boy, wahala dey. One, all their petition pre-election matters inconcurious. Oh man, I don't forget the English. You see, I thought I don't forget that. Inconcurious. You see what they said? Hey, why did I not be a lawyer? I'm supposed to inconcurious. Pre-election matters, no logo standing, nothing, lack merit. So many things. And that's the words. Those are the vocabs I've been hearing since today. Those are the key words I've been hearing since today. All the things they do not have any, they have no legal standing, nothing. Inconcurious. Incongruous. Yes! Hey, thank you for reminding me. Incongruous. Incongruous. Every petition is incongruous. And Obi is not even here. Where is Chimamanda that came to the court the other day? Where is Chimamanda? You see, I told you that it doesn't matter where you are, whether you live in America, whether you anywhere you live, whether if you are black, you are black. I've always been saying it. I've told you that it doesn't. Intelligence is not where you travel to. They don't teach you there. That is not what they don't teach you character. They don't teach you common sense. They teach you degree.
Well, we'll rise for just 15
they won't teach you about your history
and come with continue with petition number 3.
They don't teach you about those ones. If you don't have sense, you don't have sense.
You
don't finish now. Everybody
as an elderly person, I know what is going on.
Hey! Hey! Church Akbasala. Hey! Oku the over. Dave Jackson said in Sima, we shall meet in Supreme Court. My brother, when you go to Supreme Court, now there the English go finish. Now there the English go finish. That the Supreme Court the English go finish. Hello. After now, oh my God. You say stop wasting your money. I've told you people, stop wasting your money. Anyway, Obi is not losing.
I said, we're just wondering.
No, it's a consolidated judgment. They will give their contributions after
they
have read all the judgments.
Oh, my lords, please. We just needed to know, sir.
Yes, they will give their.
Thank you very much, my lord. Thank you, sir.
I didn't hear the question. Oh, Mona, go house. It's finished. We tell them, say, you don't finish, and take the joke. From day one, hit the ground. Hey, see Obus Odinma, my man. That is one of the prominent Igbo man that I know today that did not succumb to the criminality of Ipong and Biafra. That is Obus Odinma. I respect him. Because that man, if you see what they did in Imo State, that man did not allow them to win him. I'm telling you, Ipong criminals, Obus Odinma stood his ground to defeat all defeatables as well. I love him. I like him. I get him now. You see, it is finished. See our Shetima. Everybody is going home, my brother. Somebody say Obi is already feeling his appeal to the Supreme Court. No wahala. Make them come out on the street now. Make them come out. You said they want to come and shout on the street. Make them come out.
Well, so far,
you don't see how it is finished, guys.
Well, we can't tell at this time if it's the first part.
It is finished.
First
brotherly.
part of the proceedings.
It's gone.
Has just gone on the way.
Well, the justice has the fourth item, so to speak. So there's still.
We told you guys, Jagaban, the last man standing. When they come out, we are already gyrating. This is it. I told you that this time around, the people making noise will not succeed. The real patriotic Nigerians, they are going to be on the street this time around. It's already happening. It's already happening now. The gyration is already happening. You don't see how? This is happening live in Abuja. It's happening live in Abuja as we speak. Obi, wait for your Obi. Which kind? Obi not even follow for what you the talk say. The people are already gyrating, guys. It is finished. Otilo, Oyana. Let us see their noise this time around. We are waiting for them. Abi, they say they want to come on the street. Okay. Oh yeah, may wanna come on the street now. NLC strike failed. All of those things failed. We did not see Okonkwo. What's his name? We did not see Okonkwo, Kenneth Okonkwo. We did not see Obi again. Obi did not come out. Ask yourself why Obi no come. After Obi has been there, Chimamanda is supposed to be there now. He didn't come. I don't know what they used to deceive them. I don't understand what happened to them. I getting me now. Donation for Obi, Supreme Court. The same way I've been telling them. There is nothing like Biafra. There is nothing like iPunk. They keep deceiving themselves. I know it's content. Biafra is content now. They used to be doing content on social media. They say, in Sima, you don't have content. I say, I don't have content. Bunch of criminals. Told you, Obi got his advice from a madman. Is it not? Is it not? Otilo, we already said it. Guys, we are going to review this thing later. We are just this is, we told them, man, who are the naysayers? Come out and say it. Look, after you finish judgment, that is when you understand that the court is not joking. That is when you understand that it's not joking anymore. You understand me? If you finish reading the judgment from the court, do you know the number? When you finish reading it, that is when you know that this country is not a joke anymore. Go and read it now. They took time to reply every of the petition. Everything was, in fact, they took time to reply. We are already celebrating. We are celebrating already. Oh my God! Yes, sir. Obi wait for your turn. Make Obi go wait for his turn. You understand me? It's turn by turn. Obi wait for your turn. Turn by turn. Oh. Obi wait for your turn. will be on the street. It's already happening. Anyway, guys, I have to end this broadcast. It's been a wonderful conversation. Let's leave it there. We will continue this conversation later. When we come back, we'll come back with celebration mode. You know how it's going to be like. I get me. Let's go and enjoy ourselves, man. It is finished. Our president is doing well. He is already in India, taking steps, having meetings with investors. You understand me? And the thing is that, just like somebody said now, there is no turn for Obi to wait. He is forever politically crushed. Some of them, they say they wanted to merge with NNPP and PDP. Now, they don't sack Concasso from his party. So they want to merge for 2027. It's a done deal. I've told them, forget it. I told them that before the end of 4 years, there will be no opposition. They thought that I was joking. Anything what they tell you, they watch. Because I said by that time, the city boy will resolve all the issues. In fact, Nigerians will be begging President Tinubu to continue. Because he's a true leader. He will allow his boys to take over. Because it's a continuity. I'm telling you, the template is 50 years. Forget it. 50 years to make Nigeria a better place. There's already a plan. 50 years. Forget it. If you are not part of the winning team, there's no way you can win. You're gone. When I say it, just know it. We love the city boy. We know that he has plans to. He said Nigeria is back. That's it. Forget it. After how many years, Nigeria is back. And that's it. Forget it. There's no other story. So, guys, let us leave it here. We'll come back again. I've been able to do this almost 3 hours. We'll come back. When we come back, we will accept calls. People will be reacting to our conversation. You have you can call in and say what you want. I've seen lots of comments and calls already, guys. When we come back, we will talk. Ma, go celebrate. I get it me now. Stay blessed. We will continue to pray for our president to be strong and healthy. Wisdom, akonuche, according to my Igbo brothers. Akonuche, wisdom and understanding. In my own language, they say Ifiok. Ifiok means wisdom from the Bibio language. Ifiok. We pray for the city boy, for akonuche, that is wisdom, for Ifiok, knowledge, understanding, to take the right decisions, to form the right team that is going to deliver this country. We have seen that our president is focused on making sure that Nigeria is back on track. I get me now, and we are proud of it. My brother, be happy. The president said that renewed hope is here. The renewed hope agenda is here. He said renewed hope is here. Nigeria is back on track. Enjoy this moment. He said, let us enjoy this moment. And I've said it many, many times, that if you miss to enjoy this moment, you are just wasting your time. Enjoy every process that is taking us to the promised land. Enjoy every process. Enjoy this moment. If you miss it, you will miss it. You'll be among the people crying and weeping and talking rubbish. My brother, when they catch you this time around, criminal activities will be punished. I'm so sorry that I did not hear the court give fine and punishment for criminals. Because from what the court said, from the judgment today, they indicated that every petition was to undermine the court process and the electoral laws. So there's no punishment. Maybe they are lucky. I don't know why the judge did not punish them. They're supposed to be fine attached for filing rubbish cases against the government or the INEC or anything. But we will look at it later when we come. By that time, lots of analysis will take place. And then because the judgment is long, a lot of things, they said a lot of things, they addressed a lot of things, so many education, so many things we explain in that judgment. That shows you that, my brother, don't underrate anybody. The people from the southeast always say they did not go to school. They don't prove to them now. Say, they learn work. It's not by making noise. It's not by shouting woto woto. You sit down. The other day I saw Simon Ekpa put a picture of some idiot. He said this is his army. I don't know when they will go. I don't know who is going to deliver the Igbo people from the southeast. I don't understand it. Some of these criminals following this bunch of criminals on social media. My brothers, I get me now. Wisdom, akonuche, Ifiok, wisdom. Wisdom is what we are praying for the city boy. Ifiok, understanding. I think in Yoruba land, somebody said there is Egbon. Is it Ogbon? Wisdom. We are talking about wisdom and understanding for our president to take the right steps to deliver this country from the oppressors. And I also pray for all of you to be strong and healthy as well, to enjoy this renewed hope agenda, guys. There is no joy in my heart than seeing us continue to win. that the city boy defeated all defeatables. Let them come on the street. If they get mind, come out on the street. They want to come and cause problem. They want to come and destroy the. Come out this time around. We will teach you a lesson. This is not Buhari government. I get me. This is not Buhari government where Buhari did not listen to expert advice and all of that. You remember what they say? Prophecy did not work. Yes, daddy did not work. All the criminals, prophecy, and pastors that they used to deceive people did not work. You understand me? So all of us, we pray for us to be alive in good health, to enjoy this government, to be part of success in this government, to see renewed hope agenda achieved, to see everything working, to put the smile on the faces of Nigerians, just like what happened in Lagos the other day. Was it yesterday? People were smiling. People were saying Lagos is working, Nigeria is working. There is no more suffering. That is what we want. We want leaders that will make things to happen. We have the resources. We have everything. That is why we must hold our leaders, our governors accountable, because they are the one that is making life difficult for us. It is time for us to understand that the president is not the cause of the challenges in the country. It is the governors. Resources have been given to them, but they refuse to do what they're supposed to do. Go and hold your governors accountable. Stop running propaganda on social media. Stop telling yourself that Biafra is coming and they are going to divide Nigeria. They are going to scatter Nigeria. The person that said that if the judges did not make any, they are going to divide. Let us see how you are going to divide the country. Nonsense. May God bless you. May God bless our president. May God bless the Federal Republic of Nigeria. Of course, you know my name. My name is Akparawa Nsima, the first son of Idu. I'm from Akwa Ibom. Akwa Ibom Ayaya. Our prayers is Abasudium. Let God bless all of you. Stay blessed, guys, until I come your way.